That 9-year-old government servant.
For 48, no?
Writ petition is dismissed. The respondent should ensure that the petitioner is relieved of his post immediately. He's been there from 2018. 6 years, 7 years extra his work. He joined government service in the age of 9 years old. How is it possible?
May I please, your lordship? Okay, with the consent of the other side, I beg to mention item number 9 of the list.
9.
In this matter, lordship, arguing counsel, Mr. A. Boro has some personal difficulty today, lordship. Lordship, may kindly fix this matter on Monday, lordship.
It is the same 18/9/24, na? We have disposed of. There's nothing to think. We have disposed of a batch of petitions yesterday.
Kindly fix.
We have directed that all the applications should be considered by the government. That's what you want.
Compassionate appointment that already in the
That
land,
one,
your
that one
lordship.
only.
It come on that, your lordship.
It comes with okay.
Okay,
Monday on the prayer made by Mr. Made on behalf of Mr. Boro. List the matter on Monday. The matter pertains to compassionate appointment.
7.
This is the matter.
May I please, your lordship, for listing my new IA, my lord, filed on yesterday, my lord, maybe taken up on Monday, not Monday, on 9th.
Huh?
9th.
Okay.
Lordship, I beg to mention item number 47, lordship.
40.
47.
47, yes.
Kindly matter may be adjourned for today, lordship.
47 adjourned for today. Why?
Lordship, arguing counsel, Mr. P.P. Dutta has some difficulty, lordship.
Lordship, I'm appealing for the petitioner.
You're the one who wants to be transferred.
Yes,
within a
Lordship.
time.
Lordship, in fact, what he had told me that yesterday night he was suffering of fever. Today morning he informed me. So since I have not been able to join and no salary is also not been given to me.
No. Join where? Bangalore.
No, since the suspension order is under stay, so I should be allowed to join here.
No, there's no such thing. You, as per the judgment of the Supreme Court, you can be transferred in any office anywhere, within or outside the state. Only thing is that because of the criminal case.
Yes, and
that bail order.
And the rules of the IGNOU specifies that section officer cannot be transferred outside. There is a specific rule.
No, so who has to take a call on this?
They have to take a call, and moreover,
So you have to take a call.
yeah.
Okay.
And moreover, what had happened, Lordship, here he was placed under suspension for the alleged misconduct in the deputy department, not in the parent department. In the parent department, there is no departmental proceeding going against him.
But it might be due to some misconduct that had occurred in your parent department.
No, nothing. There is nothing in the parent department.
Okay,
In fact,
anyway,
next week, Lordship, because he has not been able to join, I'll demonstrate.
On the prayer made on behalf of Mr.
P.P. Dutta, lordship.
P.P. Datta, learned counsel for the respondent number 1, 2, and 3,
Yes, lordship.
who is apparently unaware, list the matter on Tuesday.
Tuesday, Wednesday.
Tuesday. Just right. One thing. Just right. The petitioner, the writ petitioner. This case is that
Lordship, can it be 9?
in terms of the bail order granted to the petitioner, he cannot leave the state of Assam. Full stop. However, the petitioner has been transferred to Bangalore, which is against the rules, which provides that a section officer cannot be transferred outside the state in which he is appointed. Appointed. Full stop. This is the matter on when?
9.
9.
Obliged.
Deeply obliged.
May I please,
Lordship, interim order.
Interim order to continue.
may I please, your lordship, I'd like to mention item number 31 and your lordship,
31.
for adjournment, your lordship. We have taken the.
31 for adjournment. No, why?
Your Lordship.
You're for the first wife. You're for the petitioner.
No, Your Lordship, respondent.
You're for the, who's for the first wife? Anyway, you wait, madam, you wait. Wait, just we'll see. We wanted some document.
Yes, Your Lordship. For that reason only, Your Lordship, we need little.
Who is to produce the decree? You are supposed to produce.
To the petitioner.
Petitioner was supposed to produce or you are supposed to produce?
We have to submit documents relating whether we are the first wife or whether we are the second wife or first
No,
wife.
no, it is your case that the petitioner was divorced by the husband, correct?
Yes, Your Lordship.
This is your case. So you have to prove it. They
Yes.
don't have to prove anything. That's your allegation.
They were to give the Your Lordship certified copy and.
They were supposed to give a certified
Yes.
copy of that trial court order.
Yes, Your Lordship.
So where are they? So let us wait for them. We'll just ask if it's there. If they have it, then we'll fix it on the date that you want. Okay, madam? You just stay around. Yes.
Lordship, I victim mention item number 20. Need to file
Yes. What about it?
item number 20, Lordship. I need to file an additional affidavit, Lordship. So 2 weeks time maybe until after due vacation, Lordship.
Okay, Mr. D. Chowdhury, learned counsel for the petition is granted 2 weeks time to file
Additional affidavit.
additional affidavit. You're for the? No, you're not there.
Hired
This is the matter after 2 weeks.
May I please, Your Lordship? May I please, Your Lordship? I will prayer for withdrawal of item number 51, Lordship.
Huh?
A prayer for withdrawal, Lordship.
Okay,
In respect of item number 51, Lordship.
51.
51, Lordship.
51. Okay, 51. You want to withdraw 51?
Yes, my lord.
Mr.
D. Bhuya, my lord.
D. Bhuyan, learned counsel for the petitioner, please that he may be allowed to withdraw the writ petition. Who appears for the other side? Mr. R.P. Bora appears for Elementary Education Department. While, P.K. Bora. While Mr. P. Saiki appears for respondent numbers 1 and 3. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. Obliged.
May it please the Lordship, I beg to mention item number 22, Lordship.
22, yes, what about it?
Some instruction is to be received, Lordship.
Huh?
Some instruction is to be received from the clan, Lordship. Can-
From whom?
We are from, for the petitioner, Lordship.
Yeah, for the, correct, you have been given enough time.
Lordship, can the matter be come after vacation? Lordship?
Why? Where is your senior? Where is he? He's here. You see, you don't ask for adjournment just for the sake of asking. You have to give some cogent reasons. You have been provincialized as a tutor on 2021. Now, what is your problem? What is your problem? Not, no, you tell your senior to come. If he doesn't come, I'm dismissing your case.
Please, this court. My lord, I'd like to mention a writ
Huh?
petition. I'd like to mention a writ petition, my lord. Service related matter. The matter currently we have to take steps in the last order. So taking the steps,
Which item?
my lord, I'm listed for listing, my lord. Writ petition.
You go to the registry.
Item 49 to withdraw.
Miss,
A Begum, Lordship. Lordship, we want to also, liberty, we want to liberty. to
Huh?
file a
with
check,
liberty.
Lordship.
Miss,
A Begum,
appearing for
Mr. A M Borbuya.
Mr. A. Borbuya, A.M. Borbuya, learned counsel for the petition. Praise that she may be, she prays that she has received instructions from the petitioners to withdraw the writ petition with liberty to file a file. Miss P. Das appears for the Secondary Education Department. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn, with liberty as paid for. Item 50. Yes.
And the time may be allowed to withdraw the petition, my lord. But we will liberty to, if necessary, will file again.
What is there?
My lord, the matter is pertaining to distribution of scooters to the students, matter.
Scooter.
10 numbers of petitioners are there. 3 of the petitioners are given scooters, my lord, after passing this order, my lord. And 7 remains, my lord. My lord, the petitioners have been assured that all the scooter will be given.
Okay, right.
care should
Mr.
be- A. Ali.
A. Ali, learned counsel for the petitioner submits that he has been given instructions by the petitioners to withdraw the writ petition with liberty to file afresh.
Yes,
Not-
my lord.
Mr. S, huh?
Not fresh, my lord. If necessary, I will file, my lord. If it's good not given, my lord. If
With
required, my lord.
afresh, naturally the
My
same
lord, my
thing.
lord.
Mr. S.
Yes,
Bria appears for
It's higher division.
Higher Education Department. The prayer of the petitioner's counsel is allowed, writ petition dismissed has withdrawn with liberty of faith.
I didn't want to vote it.
Third, Mr. S. Hawk, learned counsel for the petitioner, who submits that the petitioner's claim for provincialization has not been considered, despite the order dated 10/1/24, passed in WPC 6329 of 23, and order dated 5/2/24, passed in IAC 300 of 2020.
Right.
Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by registered post retaining within 3 days.
Right.
List the matter after 4 weeks. Mr.
Yes, Congress.
S. Count, learned counsel for the petitioner submits that no decision has been taken by the respondents on the leave period,
Yes, my lord.
on the leave period. In terms of the order dated 18/12/24, passed in WPC 828/2024. Same thing, huh? Issue.
Can it be after 3 weeks, my lord, because the person is retiring in 31st of May, my lord.
Your Bihu is coming up also. Okay. Heard Miss M. Dev, learned counsel for the petitioner who submits that the respondents have not considered equalization of pay of the petitioner with the other teachers in terms of the order dated 19/8/24, passed in WPC 4498 of 23. Same thing. Except within 3 days.
Item 4.
Yeah, right. This matter, I think, can, heard Mr. Udata, learned counsel for the petitioner, who submits that the petitioner's application for compassionate appointment has not been placed before the DLC in terms of the order dated 19/12/23, passed in WPC 7345 of 22. 4 weeks, 3 days, steps within 3 days.
Item 5.
Item 5. After some time,
Item 6.
May I please allow? Lordship, can you have a look on the last order? 7th of March.
yes, where is the original?
Yes, my lord. And in this regards also, my lord, and file additional affidavit, my lord. Lordship will compare my affidavit with original, my lord.
Verification of.
You did your class 12 where?
Lord, it is Agomani Higher Secondary.
Your,
Oh, no, class 10, my lord, in
the inks are all different.
And your lordship, Seva has to make party here, your lordship,
Ah.
because he has passed Assam Higher Secondary Education Council, your lordship, State Board Council. They
Okay,
have to make, because verification of documents
will have to be done by them.
The-
Correct,
done by Seva.
correct.
Lordship, I will.
Okay, right. Mr. P. Dekar, learned counsel for the petitioner, shall submit an application for improvement of the school of what?
Now it was changed,
For the,
school education.
what is it called?
Seva board or nothing now. Higher secondary. Assam State Education Board.
Huh?
Assam State Education
Yes.
Board.
Assam State Education Board. as no, for verification of the documents of the petition.
Yes.
He accordingly leaves this matter after 2 weeks.
Obliged.
Assam State School Education Board, Lordship.
Assam State School Education Board.
As-
What we can do is, okay, we issue notice, I think. है ना? Right, heard Mr. So. Just give me the file. Heard Mr. So.
Sir, अपने party
No
को-
keeping, no point keeping it here. Heard Mr. So.
will go implicate-
Learned counsel for, indicate that Dekha learned counsel for the petitioner. The petitioner's case is that he retired as an assistant teacher on 31/10/2016. However, he has not been paid his intermediate pay scale in terms of the order dated 19/1/2024, issued by the Deputy Director, Madrasa Education, Assam. The petitioner, who has retired in the year 2016, has made a claim to be paid intermediate pay scale for a period of more than 20 years. Full stop. As the Assam State School Education Board, Assam State School Education Board has not been made a party, the petitioner shall make the ASSEB a party by filing a proper application. Issue notice returnable in 4 weeks. Miss P. Das accept notice on behalf of on behalf of
1, 3, and 4.
1, 3, and 4. Miss R.M. Barrow accept notice on behalf of fund number 2.
Extra copy.
And Treasury Officer also. And 5, 2 and 5. Petitioner will take steps for service of notice upon the respond number 6. The next para, the
Number 2.
maintainability of the writ petition is kept open in view of keeping in view the laches and delay in filing the writ petition.
Deeply obliged.
Obliged.
This is the matter after 4 weeks.
Item 7.
Yes, madam.
Ipamuni instruction is still awaited, Your Lordship.
Okay, right. Mr. B. Purkasta, learned counsel for the petitioner, submits that the inspector of schools Naogong has been made to hold the charge of principal of KB Higher Secondary School, even though the petitioner is the senior most eligible bachelor who should have been given the charge of principal. Issue notice returnable in 4 weeks. Ms. P. Das accepts notice on behalf of
1, 2, and 3.
1, 2, and 3. He will obtain instructions with regards to why the petitioner has not been made the in-charge principal of the school.
Returnable after, Your Lordship.
Date
Pardon.
may given.
List the matter on, give a date after 4 weeks.
Deeply obliged.
Item 8.
Lordship, can this matter be taken up tomorrow, Lordship? Some order has been passed, but I'm yet to receive the copy of that order.
Acha.
Can it come tomorrow, Lordship?
Tomorrow? Tomorrow? Already? Monday? Okay, Monday? All right, on the prayer for adjournment made by Mr. D. Upamani. This is the matter on Monday.
Highly obliged.
Obliged. Item 10.
Please, Your Lordship. Lordship, my lord, the petitioner is aggrieved by the fact that he was granted promotion to the selection grade scale of pay with effect from 2024. However, he was eligible for the same from 2018, my lord. Consequently, he is also deprived of the next stage of promotion.
So have you made, but there are others who are senior to you.
No, your lordship. A similarly situated person has been granted promotion from 2018.
From the day.
But
Okay,
I
right.
am also to be granted from
Mr.
S day, my lord.
As the learned counsel for the petitioner submits that the petitioner has been granted promotion under the Career Advancement Scheme, bracket CAS, or in
From
which
senior
stage?
grade scale to
In
selection
professor
grade.
stage two, to professor stage two or stage three?
Stage 3, your lord.
Huh?
To stage 3.
To professor stage three. On 29/1/2024. The petitioner's case is that as he was eligible for promotion under the CAS with in the year 2016,
18, your lord.
18, comma. The promotion under CAS has to be made from the date of his eligibility under the CA. Issue notice returnable in 4 weeks. Mr. D. Pamanu accepts notice on behalf of respondents number
1 and 2, lordship.
1 and 2. Petitioner takes steps for service of notice upon the respondents number 3 and 4. This is the matter of the 4.
11 is similar, your lord.
1, 2, 3, 4.
Lord.
Party is also same.
Same part.
Yes, lordship.
Same order.
Much obliged.
May I please your lordship? Lordship, the petitioner herein is claiming her arrear salary, lordship. Yes,
Why after 14 years, madam?
Lordship, the impugn order is at page 37. It is the order of 2021. Her services were brought under the old pension rules by the order of this honorable court. But the arrear salary, claim for arrear salary has been denied because they stated that she served as an untrained teacher. Lordship.
Correct. Heard Miss J. Dekal, and counsel for the
A
petition.
Talukdar, lordship.
A. Talukdar, counsel for the petitioner who submits that the petitioner has been deprived of the time scale of pay with effect from 1/8/94 to 11/1/2011.
Lordship.
While impugned order dated 10/9/2021 issued by the Director Elementary Education. Issue notice returnable in 4 weeks. Mr. P.K. Bora accepts notice on behalf of
1 and 2.
1 and 2. What about the others?
Treasury officer.
Huh? Treasury Officer, Miss R.M. Barwa, accepts notice on behalf of point number 3. This is the matter after 4 weeks.
Much obliged, lord.
May it please, your lord. Lord, the petitioners, they are tutors, my lord.
So you want it disposed of as page 84?
My lords.
Yes, madam. Can we dispose it of in the same manner as page 84?
Yes, your lordship.
Okay, heard Mr.
M.K. Das.
M.K. Das,
My lord.
learned counsel for the petitioner. Petitioners
My lordship. Petition.
who submits that the petitioners are serving as tutors in various elementary schools in the state of Assam, and they are presently receiving fixed monthly salary. So then the rest, same. Then after that, from here, page 84,
84.
from here, from here to, I think nothing has to be changed except,
Nothing, my lord.
wait,
Except
at
the
para 2, Miss P. Das appears for respondent number
1, 3, and 4.
1, 3, and 4. Anybody else? While Miss R.M. Barwa appears for respondent number 2. Okay. Full stop. They submit that they have got no objection with the prayer made by the petitioner's counsel, in view of the fact that this is a covered case. Okay. Then the rest will be same.
deeply obliged.
Deeply obliged.
My lord, at this stage, I think a notice should be there.
Why don't you go to the educational tribunal?
Tribunal may not, because your question is whether we are entitled to the benefit from 2001. Similarly, all citizen process have been given our.
2001 now, it's already set, it's
25.
ultra virus. Then,
Yes.
no, how can you
No,
get the
in
benefit?
23 only, we were, 21 only we have been granted provincialization.
Huh?
After long
Maybe,
years.
but then 2011 is gone. Now it's once a statutory law has been declared to be ultra virus, the constitution,
yes.
then it's known as.
Well, that's what,
So,
so
and-
this honorable court will have to consider now whether similarly situated process having been granted the benefit from there and all these conditions.
No,
being the same.
those persons who have been granted the benefits of the 2011 Act that are saved already.
Malad, they are saved in
But
that.
Very lately, your lordship.
correct, no.
Malad, let them come up with it. Why they could not
No,
consider?
no, I think you should make a claim under the 2017 Act.
2017 Act, we have been provincialized.
We have been
We have been provincialized under 2017 Act.
correct.
We want now that why not that should be given effect to from a day when all other similarly situated persons, because that time had there been no order of this honorable court saying that you cannot go ahead with 11, that act, probably would have been done that time itself. That is my
Unfortunately,
guess, madam. So lordship will have to consider it, whether there is some parity and there can be a.
how can there be? You just tell me the case. Let
that
us
be
see.
hard, my lord.
Let me hear you now. Let me
No,
hear you now.
my lord.
The today's for motion. Let
And in
me
that case, if lordship wants to hear it on
Yeah.
merit,
naturally
let's
whether
fix on
whether
some
this
other
is
day.
whether
some
this
other
is whether this is a
No,
fifth
but we have
case.
to be happy to argue this case and get it finished because
No,
instead of
no,
getting it
I
pending,
don't want to
I
finish.
thought this way that
I want to know whether notice can be issued.
yes. Malad, I
Sure,
think
you have to
notice can
convince
be
me
issued on the
that
simple
notice has to
ground.
be issued.
Notice can be issued on the simple ground that when all such similarly situated persons, including those institutions, and requirement is the same under the 17 law also, 2006, the recognition, all that is there. So having been the same, background is the same, being provincialized, whether we are entitled to that retrospective benefit.
How can you?
Now,
When if it has
prima
already been
facie-
done, that's a different
now,
thing.
if prima facie lordship's view is that we cannot, let it be taken up next week, lordship will hear it, I will come on merit. I will argue. Today is the motion day. I expected, let them respond to it. If they say no, let us shut out.
No. You see, I have to be first convinced that there is a case for issuing notice.
Well, fine, my lord.
It
If
is
lordship
not a
wants to hear me on
mechanical.
that point,
I
no.
cannot act mechanically.
No.
Every case that comes, okay, notice. That is not the case.
No, not at all, not at all. There are decisions also of this honorable court that time granting similar benefits subsequently. I will come up with all these decisions. I will come up with all these decisions. Let it be a fair deal. At least whether they will know they should get it or not.
The fair deal is you should have come prepared today itself.
But today, for full length hearing,
Not full length
Sorry, I
hearing to
could not.
convince me.
sorry,
Yeah.
I could not.
Yeah.
And that because there are so many other things. Or tomorrow,
Any day.
tomorrow, no issue. Malad, I have no issue. Only thing is, I was out of station. I have landed the morning.
Oh.
Uh,
No
So-
problem, no problem. You come prepared. No, I'll give you time. No, not an issue.
Malad, because here,
I
I
are
want
you
Malad
are you
to be
going to
fair enough,
be
Malad.
are you going to be present tomorrow?
Yes, sir, lordship.
So we do it tomorrow. But it'll take time, no? The other
Or
matter.
Monday, your lordship.
Tuesday?
Yes.
Okay, right. On the prayer of Mr. K.K. Mahanta, learned senior counsel, list the matter on Tuesday.
Right. On Wednesday, my lord.
The petitioners herein are praying that they should be allowed the the benefits under the deficit system of grants in aid at par with 277 numbers of
Teachers.
Huh? Teachers.
Teachers.
With effect from 1 to 2001. The petitioner will have to, the petitioner's counsel will have to address this court as to why this, as to whether the writ petition is hit by laches and delay, and as to whether the 2011 Act can be pressed into play when the same has been declared to be unconstitutional by this court. In the year 2016, to stop further, the 2017 Act is now the only act in operation by which provincialization of service can be done. This is a matter on Monday, Tuesday.
On Wednesday, night. So Tuesday, there's some difficulties.
Good night. What is it?
Deeply.
Bye-bye.
Mayor, please, Lordship. Matter pertains to the completion appointment, ma'am.
Item 9,
Item 15, my lord.
15.
Yes,
Okay, 15. In terms of yesterday's order,
yes, ma'am.
correct. Mr.
T shake.
Huh?
T shake.
T. Sheikh, learned counsel for the petitioner submits that the petitioner's application for compassionate appointment was not recommended due to non-ability of vacancies by the DLC. Besides, full stop. Further, the government of Assam had issued a fresh OM dated 18/9/2024, wherein it had held that the policy on compassionate appointment would not be applicable to family members of the government servants who had expired prior to 1/4/2017. He, however, submits that a batch of writ petitions, the lead case being WPC 342 of 2025, had been disposed of on 3/4/2025 on the consent of the state government and the petitioners therein, which was to the effect that the state government would decide on merit all pending cases relating to compassionate appointment in this court, wherein the OM dated 18/9/2024 had been put to challenge. He accordingly submits that the present writ petition should also be disposed of in line with the order dated 3/4/2025 passed in a batch of writ petitions, the lead case being WPC 342/2025. Mr. P. Saikia, the learned counsel for the
1, 3, and 5.
1, 3, and 5. And Ms. Pida said that
Education.
1, 3, and 5. And
Elementary is there, director of.
elementary. Who is elementary? And who is elementary? Yeah, and Ms. N. Fukan for the elementary education department. No, Ms. N. Fukan for elementary education department. Submit that they have got no objection with the prayer made by the petitioner's counsel. Next para. Para 9 and 10 of the order dated 3/4/2025 passed in WPC 342/2025 states as follows. As the counsel for the parties submit that the present case should be disposed of in line with the directions passed in WPC 342/2025. The present case is also disposed of in line with the order dated 3/4/2025 passed in WPC 342/2025.
Lord, this matter has become infructuous, my lord, since, my lord, it's a.
We have misplaced the brief of this.
Well, yes, it has become infructuous.
My
Why?
lord, since, my lord, he took admission in 2008-9,
Ah,
and after 8 years, my lord, in ninth year, he applied for back papers, my lord.
Ah.
But since, my lord, that 8 years, my lord, cut off year, 8 years, stipulated year, that is, my lord, already elapsed. So admit card has not been issued. And that was for the year 2017 again.
There was a representation pending. I just saw the file, Lordship. There was a representation pending. They did not consider, Lordship. And
Mr. Counsel, this matter pertains to which year?
2017,
2017.
2017, Lordship.
So,
Lordship,
what is to be done?
If my learned friend wants some time, my lord, I don't have any objection, my lord. I think he is in.
This is,
predicament.
this is the writ petition pertains to 2017,
Lordship.
but you were admitted to the LLB course in 2008-9. Now, how many years have passed? Now it's 2025, Mr. Counsel.
I know.
He'll be having a thick beard by now. You have got to, you cannot just say that if you can't, if you do not have, if you're not communicating with your client anymore, say that. We close it. Why keep it pending?
Lordship, otherwise there was a representation pending before the authorities. And immediately after that, we approached this honorable court. Lordship, since the judicial time consumed in deciding this case, Lordship, that is not a delay, Lordship. So,
No, I'm not on that. I'm on the issue of you not being able to communicate with their client and giving us something. There's no point keeping this case here till a sweet time, and till the time you talk to your client at your own sweet will. You have got to talk to him. You talk to him now. We'll take it up at 2.
Lordship, the brief is not there.
Huh?
The brief is not there with me, Lordship.
Brief is with whom?
Misplaced it, Lordship.
You have misplaced it. Then what are you going to do? What is your next course of action? How are you going to contact your client? When did you misplace the brief? 20 years ago or when? 10 months ago, 1 month ago, 1 day ago, when?
I
You've
think
got no
he's
idea.
in predicament, my lord, at least last chance maybe.
Oh no, that's
What did-
okay. But then I want to know what he's going to do. Because the next time he comes again, he's going to say the same thing. So what are you going to do?
At least one chance may be given, Lordship. That's for appearing in the examination, Lordship. That was the prayer in that petition, Lordship.
I've got to decide the case on merit.
Yes, Lordship, there is a judgment of this honorable.
I want to know what is the client still pursuing the matter or not?
Lordship,
You call him. Let him come. Right. Mr.
I'm MP Sharma, Lordship.
MP Sharma appears for the petitioner and submits that he has misplaced the brief. The petitioner's case is that he should be allowed to complete the LLB course beyond the 8 years that are allowed by the authorities for completing the LLB course. It is also seen that The petitioner had joined the BA LLB course in University Law College in the year 2008-9. And as on date, 16 years have passed since then. Mr. MP Sharma shall, by the next date, obtain definite instructions from his client, from the petitioner, as to whether the petitioner wants to press this matter.
I appear on behalf of all the respondents.
Mr. PJ Fukan appears for all the
All
respondents.
the respondents.
List the matter on when?
The next week, Lord, or immediately on reopening, Lord. I'll get some more time, Lord. Then it's.
List the matter on 5th May.
Obliged, Lord.
Most of it.
Second. May I please, your lordship, let this matter be taken up after some time? My senior is giving vote number 21.
Yes, Mr. Bora.
Yes, my lord.
Bring the undertaking, my lord. One petitioner has already expired.
Oh, which petitioner is filed?
For no.
There are three petitioners. There's Swarna Buragohain,
My lord, she has expired.
Chiang Mai,
Go
Chiang
ahead.
Mai.
Yes,
It
my lord.
reminds me of Chiang Mai.
Sang. Here Gunin Bora and
So Gurin Bora and Kabita Gogoi.
Gogoi
asking.
has given their undertaking.
Yes. Where is your senior? Who's your senior? What is his name? Huh? Mr. NJ Gogoi. Okay, right. Tell him to come now. Tell him to come now. Right. Mr. NJ Gogoi appears for the petitioner. Mr. PK Bora, Learned Counsel for the Elementary Education Department. You call him.
Material.
Submit that. The writ petition has become infructuous in view of the fact that the petitioners number 1 and 2 have been accommodated as tutors or
My
what?
lord.
Have been accommodated as
Designation assistant teacher.
assistant teacher,
My lord.
assistant teachers on the basis of orders dated 30/1/2021. In 791 Barichawa LPS and 15 number Chalkora CHAULKORA LPS respectively. He further submits that undertakings have been submitted by the petitioners number 1 and 2, which is to the effect that they would not be governed by the Assam Service Pension Rules 1969. There is nothing with regard to arrears, Mr. Counsel.
My lord, yes, my lord. They cannot claim, my lord. They will decline the past benefit. My lord.
Huh?
They have declined the past benefit, my lord.
Where? Nowhere is it said that.
But after accepting this, my lord, appointment, they have declined the appointment.
Where is it? It does not say that.
That is not there, but
Then?
only thing is they governed by the new set of, new pension scheme.
Huh?
They will govern by the new pension. scheme.
That is a different thing, but area salary, there is no undertaking. Your officers have not done a good job, it appears. So out here, the prayer is for area salary.
Well,
Next para. On perusing the next, he further submits that petitioner number 3 has expired. Next para. On considering the undertakings made by the petitioner number 1 and 2, there is nothing indicated therein that the petitioners number 1 and 2 have waived any right of theirs to claim arrear salary. Accordingly, leave this matter after 4 weeks to enable Mr. P.K. Bora to obtain further instruction. There's nothing here.
I'll.
Next. Yes.
My lord, I'm for the headmaster of the school, my lord. And
Lord, as
regarding,
per the last order, my lord, my respected friend was required to obtain instruction, my lord, that regarding the proceeding as well as the salary.
Yes.
yes,
paid
my
or
lord,
not.
regarding the proceeding, my lord, after suspension, my lord, the managing committee of the school, my lord, they did not take any decision. And regarding the salary part, my lord, the seller, she did not receive any salary, and that has been clarified by the director himself, my lord. And running page 50 of my affidavit, my lord, the last page of my.
Only page 50.
50, my lord. In the order itself. my lord. Last paragraph.
51.
50, my lord. Annexure K, my lord.
Your affidavit. What
My
is
affidavit.
this?
You have writ petition to believe.
Writ petition, my lord, of writ petition.
How many writ petitions are there? There's one.
Only one.
Only one writ petition.
Page 50?
Page 50 of the.
15.
50, my lord.
It is not
The-
there.
You do not have 15. There is 50. Just a minute.
50
Okay.
of the, my lord. Affidavit
50,
filed by
oh,
the, my lord, yes.
50.
Affidavit filed by the.
Okay, yes,
In the last part, my lord.
yes.
Order itself, my lord. Since the Assam Venture Educational Institution within bracket Provincialization and Services Act 2011 amended in 2012 and 13, which was made unconstitutionally invalid as per the Honorable Court order dated so and so, passed in WBC so and so. The service of the petitioner could not be provincialized under the purview of said Honorable High Court order dated so and so. Hence, the payment of salary cannot be made to the petitioner against non-existent and non-provincialized posts in the said school. This is the stand taken by the director.
2000. Order was passed in 2017.
2007.
Let us see this order.
My lord, the in the affidavit, my lord, at page 23 is the order.
Writ petition.
No, my lord, I am referring to the same affidavit, page 23, my lord. My lordship has already perused this, my lord, on the last occasion also.
I don't remember. I peruse so many writ petitions every day.
My lord can skip, I'm not troubling my lordships with the few pages, can directly can come to the operative part, my lord,
Ah,
which starts at page, my lord, 32, my lord, from
Yes.
paragraph 20, my lord.
yes.
Ma-
This writ petition, reinstate the writ petition is you.
Yes, my lord. Lord, what was happened, my lord?
Allow to Yes. What is so difficult?
My lord, she was reinstated in the, to the post of assistant teacher.
Reinstated.
Thereafter, my lord, it is the managing committee, my lord, who took a decision to, my lord, initiate a, my lord, disciplinary proceeding against her, since she remained absent for a long period and she.
Okay, that's a different thing.
Very good, my lord.
Yes.
You initiate a disciplinary proceeding, that can be done.
By
There,
the
there will,
committee. The school managing committee, my lord.
a school managing
Not the
committee,
university.
that can be initiated.
Yes, my lord.
But then you have got to first, he has to be given her pay after reinstatement.
The
So where is
salary
that?
part, my lord, the director himself, my lord, he has clarified after disposal of this writ petition, my lord, by virtue of order dated, my lord, 28th of December, my lord. Again, I'm referring to, my lord, page 50 of my affidavit, my lord. My lord, in the finding itself, my lord, if you should kindly peruse, my lord.
Yes.
As per the Honorable High Court order dated so and so, 8/3/2017, passed in WBC number so and so, that is the disposal order, my lord. And WBC number so and so of Amina Khatun, it was instructed to the DO Naga by letter.
You see, this is not a question of the petitioner being provincialized.
Fine.
She has already been provincialized. It's a question of the petitioner being reinstated. There's a word. In that writ petition,
Fine.
it does not say that the petitioner should be provincialized. It says reinstated.
Reinstated.
Reinstated as what? Was the petitioner provincialized earlier?
No.
Oh, not
Not earlier.
not provincialized.
No,
Not
my lord,
provincial.
my lord, what has happened, my lord? The headmaster and his wife, my lord, it has been recorded in detail, made an access to oust me from the post of second assistant teacher. Accordingly, my lord, by initiating a so-called proceeding, my lord, which has never been initiated, I have been ousted by following the due.
Okay, so you should be reinstated as a teacher,
As a teacher.
non-provincialized teacher.
As a teacher,
As a
but there
teacher.
is a clear-cut mandamus has been issued that you pay. Now, how they are going to pay, that is the issue. For that, my lord, they should initiate the process of provincialization and they have to pay me.
I
That
do
is-
not know. Because provincialization cannot be done under the 2011 Act.
Whatever,
Yes, my
my
lord.
lord, the subsequent acts are also available, my lord. Under that, they.
But you have to make an application, I
No,
think.
no, my lord, they cannot get rid of an order of the division. This order has been appealed before the division bench also, my lord. The division bench has also upheld this order, my lord. Now, my lord, a mandamus which has been issued, the director is not an appellate authority, my lord. Kindly see, the order of which my learned friend is referring is amounts to his, my lord, dictating like an appellate authority,
Correct,
which he
correct.
cannot, my lord, which he cannot. This type of, my lord, attitude of a
May I
court
submit, my
of-
lord? My lord, by referring to this order, my lord, it is the department, my lord, concerned department, who will have to take a decision, my lord.
So who are you?
I am the headmaster of the school. I cannot take any decision, my lord. I cannot do anything.
But direction for him to take a decision. Now, if he,
I cannot
if he has
do
any trouble or difficulty, he can.
Only I can reinstate the petition.
My lord, the review of-
Have you reinstated the
Yes, my
petitioner?
lord. I have
According to
reinstated.
them, I have been reinstated.
Are you teaching?
My lord, I have been not allowed to go even enter into
No, my
the
lord,
school
that's wrong,
premises.
I don't know. That's I don't know.
My lord. But my lord, as per my learned friend, my lord, they have reinstated.
Show me the reinstatement order.
My lord.
Lord, page 40, my lord, lecture G of my affidavit. Resolution.
No, order.
Where?
My lord, in the first paragraph itself, my lord, today on 14/11.
It's a
Just above the
executive committee meeting.
Committee meeting, they took a decision to reinstate.
Yes, where?
In the first paragraph, my lord, today on 14/11/2017, one emergency meeting of SMC is held in so and so madrasa. Said meeting is presided by the executive committee president so and so. While discussing about the objective of the meeting, the headmaster says that as per the Honorable High Court order dated so and so, in WBC so and so, Musamad so and so is allowed to join as second assistant teacher on 3/7/2017. He was allowed to join me.
My lord, this is mere a resolution, my lord. A
The
resolution is,
basis of that resolution, my lord, he was allowed
resolution
to
is
join me.
required to be followed by.
This resolution was passed by the school managing committee, my lord.
That is
On
correct.
the basis of this resolution, my lord, she was allowed to join in the school, my lord.
My lord, this resolution is required to follow up by of an order. This is their paper and their book, my lord. What is written there, I do not have the access, my lord. At
No,
least,
but then you said that you were not allowed to join, so you
No.
knew it
my
then.
lord, I have been not communicated with this only when this affidavit has been filed, my lord, before this honorable court. Then only I could learn, my lord, that this is a resolution they have adopted. But till
What,
date, my lord,
who was giving the pay of the petitioner?
no, nobody is paying me.
Who is to give?
My lord, it is the, my lord, department, my lord.
No.
That's a completely incorrect fact, my lord, which has been placed. Your lordship will kindly see the prayer in the repetition. What was the challenge in the repetition in the backdrop of the judgment that was passed by the revision?
Ah.
bench, my lord?
Set aside and call the show
Whereas
cause
the
notice.
show cause notice, set aside the impugned disciplinary proceeding and pass further order as this honorable court may deem fit. Now, my lord, this is on the backdrop of the judgment of the division bench that is at page 67. Where the earlier termination by the managing committee has been held to be bad as it was in violation of the rules of 2007, the non-government management rules. Now, my lord, this school undisputedly at the time when the petitioner was terminated was a venture school.
Okay, it was a venture school
That was a venture school.
at the time.
And we never had a role. We don't pay the salary. We don't appoint the teachers. It is only the managing committee. And therefore, page 69, the direction was to the managing committee. The division bench upheld the order of the honorable single judge. That was the direction of the honorable single judge. Your lordship will find at page 60.
62.
Directing the managing committee to reinstate the petitioner. Now, there cannot be a question of salary, Miller, because by this time, the speaking order says, by this time, that post has already been provincialized by some other teachers. So, this is a dispute which is with regard to the petitioner and the managing committee.
What incorrect facts I have submitted? There is no incorrect facts, my lord. As the allegation has been leveled by my learned friend, my lord.
No,
My lord,
not
there is
said
a-
to you.
Oh, okay, then I am sorry, my lord.
Look, my friend was saying that it is the state who has to pay, it is the department who has to pay.
No.
Therefore, my lord, I have
There's
clarified.
no
that.
question of.
Yes,
Yeah.
there is no
If
question.
you have been terminated at the time it was a venture school,
My lord.
state has got no role to play. Has got nothing to do with it.
No, my lord, this,
And
what
until-
has happened, my lord, while this order was passed, my lord, the entire writ petition was allowed.
Maybe. But
Once
then you
it-
see,
My-
it pertains to a period
my-
when you were terminated.
No.
It does not pertain to a period subsequent.
Yes.
Supposing a
Mal.
person is terminated today from service,
my-
his case is decided after 20 years. Do you mean the effect of that court order will be from that date? It will not relate back to today. It will relate back to today.
That is, I am not
The
disputing
same
on
thing.
that, my lord.
So
Now-
your case,
when-
so there's no point going into that, skullduggery or trying to find some
No, my lord, now then what will-
alternative.
Then, my lord, my lord, with all respect, my lord, what I humbly beg to submit, my lord. As there is an order passed by the honorable learned single judge and that has been upheld by the division bench. Now, the manner in which the order has been floated and not been complied with. That's why, my lord, this contempt petition as well as
That
this
contempt petition, so we will decide on its own.
my lord,
That is a different issue.
my lord,
Now with regard to this writ
my
petition,
lord, my lord.
now,
Now, writ petition's prayer, my lord, what I have made is
Ah.
the, my lord, if my lord may be pleased to find the prayer part, my lord.
just a minute. You see,
My lord.
now there is another, you see, the thing is that the single judge has held. Now this, okay, who has initiated the disciplinary proceeding?
Not the managing committee of the school.
That cannot be done.
My lord, it, then the second part of the order, my lord, not single judge, my lord.
Please come to page 62.
It will be recognition.
Come to page 62.
My
You read from the second line.
perform her duties as the second assistant teacher by paying her regular salary and allowances, subject to the fulfillment of the above condition.
Subject to the fulfillment of the above condition.
Yes,
Then you read. It would be.
open to the school management to initiate disciplinary proceedings.
Yes. So first you have got to pay her regular salary and allowances. Then only you can initiate proceedings against her. So till you pay her, you cannot initiate any disciplinary proceedings against.
I'm trying to submit, my lord.
Huh?
You will kindly hear me, my lord. Before, my lord, passing this order, my lord, disposal order, my lord, the respondent number, you know, the other, my lord, incumbent, my lord, whose post was provincialized, that was provincialized much earlier occasion. And thereafter, this disposal order was passed when the school was at venture
Maybe
stage.
provincialized.
Lordship will kindly.
You
hear me.
see, there's no point hearing you. You see, let us not go astray. If you think that this order is not implementable anymore, please file a review. Say that this order is now implementable. But this order as it stands today it has been upheld by the division bench. That's all. There's nothing. So whatever explanation you give
My lord,
is
the
not going
later
to
part,
help.
Lordship will
Huh?
kindly hear. Lordship will kindly see the later part also, my lord.
Yes,
Along with that, my lord.
yes.
Subject to the fulfillment of the above condition, it would be open to the school management to initiate disciplinary proceeding against the petitioner by following the statutory provision
Correct.
as laid
Correct.
down under the Act 2006.
Correct.
Yes.
Correct.
As
You do
such,
that.
my lord, the school managing committee, my lord, they initiated a proceeding, my lord, against this.
Sorry, that's I'm striking it down. I'm setting aside. You cannot. How can you do it? The case is clear here. And this has been upheld by this single bench order has been upheld by the division bench.
My lord, the director himself, my lord, Lordship, again, I'm referring, my lord, for a moment, my lord.
You pay first.
Lordship will kindly see, my lord.
Then we'll take up the
Lord,
contempt.
the why
Right.
the
Heard, mister. You can go to the division bench. Heard, Mr. A.R. Bhuya, learned counsel for the petition. Also heard Mr.
Zaid Hamad,
Learned counsel for the
that's one number 6.
that's point number 6. Mr. B. Kaushik appears for respond number 1.
1, 2, 3, and 4.
My lord, the dispute arose, my lord, when the school was at venture stage, my lord. And
Maybe.
after terminating the, my lord, petitioner, my lord, and in the meantime, the post of, my lord, the other incumbent got provincialized.
You just take this order dated 3/1/2018. Para 2, para 3. So, sir. The next para will be the order dated. No, no, the order, the operative. No, the relevant paragraph number 21 of the judgment and order dated 8/3/2017 passed in WPC 963 of 2013 states as follows, huh? Page 61. First up. Being aggrieved with the order dated, with the judgment and order dated. Don't say judgment and order, say order dated. Order dated 8/3/2017, passed in WPC 963 of 2013. The respondent number? 6. Filed an appeal which was registered as WA 84 of 2017. Next para. WA 84 of 2017 was dismissed while order dated 24/3/2017 by holding that it did not find any good ground to allow the appeal or to disturb the findings and the decisions of the learned single judge. The above, next para. The next para, huh? Mr. What is your name again? Z. Ahmed. Ahmad. Learned counsel for the respondent number 6. Respondent number 6. No, next, no, don't put that. As the petitioner, case is that next. The writ petitioner has thereafter filed the present writ petition on the ground that show cause notice dated 9/11/2017 has been issued to the petitioner without reinstating the petitioner into service and without paying her the regular salary and allowance. Next para. The petitioner's counsel submit that despite the order dated 8/3/2017 passed in WPC 963 of 2013, the petitioner has not been allowed to join her post in the school.
When no reinstatement formal order had also been issued.
Further, no formal reinstatement order has been issued
Only
to the
legal
petitioner till date. He also submits that in view of there being a violation of the order dated 8/3/2017 passed in WPC 963 of 2013, the petitioner has also filed
Milord, this is a
a
wrong
contempt case, huh?
Page 34, Milord. It is on record, Milord.
Page?
Page 34 of my affidavit, Milord. It's a wrong submission, Milord. Annexure E, Milord.
Page 34.
Yes, of my affidavit. Annexure E. By virtue of an order, Milord, 1/7/2017. The petitioner was reinstated. Milord.
Okay, that is his submission. He can say anything. Okay. The petitioner has filed contempt case number C of 2018. Contempt case number 218 of 2017. 218 of 2007. Next para. The petitioner's prayer in this writ petition is to set aside the show cause notice dated 9/11. Oh, no, then I've said that. No, I've not said that. Did I say about show cause? Submit that in this writ petition is that the impugned show cause notice dated 9/11/2017 should be set aside. Issued by the respondent number 6 should be set aside as the same is subject to the petitioner being allowed to perform her duties as a second assistant teacher and by paying her regular salary and allowance. Full stop. Next. Mr. Zaid Ahmed, learned counsel for the respondent number 6 submits that though the petitioner has been issued order dated 1/7/2017, reinstating her into service in compliance with with effect from 1/7/2017 in compliance with the order dated 8/3/2017 passed in WPC 963 of 2013, the petitioner has not rejoined her post. Full stop. Full stop. That's all.
My lord, and thereafter, my lord, the school managing committee, my lord, initiated the disciplinary proceeding against the petitioner. On the
Thereafter-
salary part, that could not be paid by the school managing committee. Otherwise, the order was complied with, my lord. Direction.
Further, the full stop. As the petitioner had not rejoined her post, show cause notice dated 9/11/2017 had been issued to the petition, thereby initiating a disciplinary proceeding against the petitioner by following the statutory provisions laid down in the
2006 Act.
what act is that?
Yeah, some non-government educational institutions. Management Act.
Assam Non-Government
Educational institution.
Institution.
Within bracket,
Educational
Regulation and
Institutions
Management Act 2006.
bracket Regulation and Management bracket close Act 2006.
And the Assam non-government educational institution regulation and management rules 2007.
Act and rules.
And what rules?
Similar, in place of act, my lord, rule. has been
Rule will
taken.
come.
Instead of
No, my
okay.
lord, there is an act, then followed by the rule.
And the rules, huh?
Act
And the connected rule.
Miles.
Rule
And the
2007.
connected rule. Frame there under. He also submits that the post of the petitioner has been provincialized.
Provincialization.
Provincialized.
No, your private response.
Huh?
My post has not been provincial.
Petitioner.
That's what I'm saying.
Fine.
Then don't say that. No need. Mr. B. Kaushik, learned counsel for the Elementary Education Department, submits that the petitioner service had been terminated by the school management committee during the period when the Kado Moni Emi Madrasa School was a venture school. And as such, the state respondents do not have any role to play in respect of the directions passed by the learned single bench, by the coordinate bench in the order dated 8/3/2017 passed in WPC 963 of 2013. Just say by this court, by this court. Full stop. That's all.
Now we have the rule to pay the salary.
Full stop. As such, the question of payment of salary and allowance, the petitioner the onus of paying the salary and allowance of the petitioner is on the respondent number 6 and not the state government. Full stop. I have heard the learned causes for the process. The sole issue that has to be decided in the writ petition is as to whether disciplinary proceeding could have been initiated by the respondent number 6. In terms of the order dated 8/3/2017, passed in WPC 963 of 2030. Para 21 of the said order dated 8/3/2017 makes it abundantly clear that the initiation of a disciplinary proceeding against the petitioner could only be done after the petitioner was reinstated back into service and allowed to perform her duties as a second assistant teacher, and after paying her regular salary and allowance. In the present case, as it is an admitted fact that the petitioner has not been paid her regular salary and allowances, the initiation of a disciplinary proceeding by way of the show cause notice dated 9/11/2017 is in violation of. No, it cannot be done. In that view of the matter, the show cause impugn show cause notice dated 9/11/2017 issued by the respondent number 6 to the petitioner is hereby set aside. The writ petition is accordingly allowed. That's all.
Lord, may I pray, my Lord, the direction may be issued to allow to perform my duties without any
First
obstacle.
up, the respondent number 6 should ensure that the petitioner is allowed to work as a second assistant teacher and pay her the pay and allowances as has been directed in WPC 963 of 2000. Now in the contempt.
In fact, the order passed by the concerned director, my lord, after disposal of the earlier petition, my lord, that has not been put to challenge by the petitioner himself, my lord.
That is a different issue.
That is with regard to not provincializing her service.
Yes.
That is a different issue. That so he can file a writ petition. That's a different issue. That is not the issue. But what about this contempt? What to do?
The contempt was against the director as well. He was
It cannot be against the director.
Because the direction was against the 5 and 6. I'm not.
Let us see who is the out here. Director, headmaster.
My Lord, if the order is.
Okay, headmaster, yes. What to do?
My lord, we reinstated the petitioner, my lord. Only we said that we expressed our inability regarding the payment of salary. Otherwise, my lord, the direction given by this honorable court, my lord, was complied with, my lord.
No. You have you cannot implement some of the direction, but you can implement some other. It's
By reply.
you what reply? Everything is clear. This order makes it clear. You have been asked to reinstate her first floor.
Fine.
Second floor is you have been asked to allow her to work as second assistant teacher. Second floor.
Done.
Third floor is pay and allowances. Not done. Fourth floor, disciplinary proceeding. Now, you have done the first part. Second part, no. Third floor, no. Fourth, we have built the fourth floor on air. Is it possible? You want to implement some portions of the order without following everything in its entirety.
Who will pay the salary, my lord? That is a big question, my lord.
That is your headache.
That
We do not know.
the headmaster cannot pay, my lord. This is
The
the
school
difficult-
management committee will have to
Because
pay.
my lord, he was terminated when the school was at venture stage, my lord. His post
Maybe.
was never provincialized, my lord.
You see, why didn't you go, then you lost in the division bench also. Now, what is this court going to do? I am a single, this is a single bench. Now there's a division bench which has upheld the order. You go in review maybe to the division bench or to the single bench. Saying that, where should I pay? How do I pay? But for this court, in a contempt proceeding, I have very little scope. Only thing I have got to see is whether the order is complied with or not. That's all.
It is partially complied. And regarding the salary part, my lord, I am unable to, my lord, release the salary.
Whose fault is that? You are
I'm
saying
very
that you are
difficult to
unable to pay the salary. At the same time, you're initiating disciplinary proceedings against him.
It is the managing committee who took the decision, my lord.
Whoever, Mr. Counsel, you have a plate full of rice. You're saying you'll have that one in the middle and that one at the side. The rest around it, I will not have. A very difficult choice you're making. And you have got this big spoon and you're going to choose that one piece of rice. Not possible. So then you go to the authority. Otherwise, now I have got to initiate steps against it. What do you want? Should he come?
Kindly allow me some time, my lord. In the meantime,
Sometime for what? Have you filed an affidavit?
I'll refer it to your lordship, my lord, after 2 weeks. Lordship will kindly allow
Affidavit
2
has been filed. Right. Right, Mr. A.R. Bhuyan, learned counsel for the petitioner, and Mr. Z. Ahmed, learned counsel for the. That's point number 2. The order dated 8/3/17 passed in WPC 963 of 2013 has not been complied with, inasmuch as the petitioner has not been allowed to work as a second assistant teacher, besides not being paid her pay and allowances. Full stop. Mr. Z. Ahmed, learned counsel for the respondent number 2, submits that the school management committee does not have the resources to pay the pay and allowances of the petitioner. Full stop. Be that as it may, the fact remains that the order of the single judge has attained finality, as the same has been upheld by the division bench of this court in WA number 102 of 2017. Full stop. In that view of the matter, this court is of the view that the only issue that has to be looked into is whether the direction passed by this court is being complied with or not. On the prayer of the counsel for the respondent number 2, this is the matter when?
Just after vacation, my lord, beginning vacation.
On 24th. 24. Huh? Full stop. Next, Mr. B. Kaushik, the learned counsel for the respondent number 1, submits that the directions passed in WPC 963 of 2013 only is to be implemented only by the respondent number 2, as the petitioner's termination from service had been done while the school was in the venture stage. This is the matter on 24.
Obliged. Highly obliged.
No one appears on behalf of the petitioner. Yes, but what to do?
Lordship, my affidavit has been sent for vetting, Lordship. In this case, Lordship, she is praying for the declaration of result of normal training course, Lordship. And so far as my instruction is concerned, her name was not found in the list of candidates who appeared in the supplementary examination. So I think this affidavit will.
Okay, right. No one appears for the petition on call. Mr. P. Nayak submits that the affidavit of the respondent number
SCRT, Lord.
of the SCRT has been sent for vetting, and the same will be filed within,
Next week, Lord.
10 days. This is the matter after the vacation.
May it be pleases your lordship. This is the matter of 2019, your lordship. We need to reconstruct the file, your lordship.
No problem, my lord.
That much I know, yes, but he has been provincialized.
No, my lord. I have been appointed as a tutor,
Okay.
but my name was left out, my lord, somehow. They have stated that.
Okay, right. Ms. P. Das, Learned Counsel for the Secondary Education Department submits that the records have been misplaced and she accordingly needs some time.
I have a problem.
Lives the matter after
3 weeks.
3 weeks.
Deeply obliged.
Okay, have you filed affidavit?
Not yet, your lordship.
Madam,
I will.
Huh?
they have filed, madam.
They are filed.
Both of them have filed, madam.
Deeply obliged. So, second.
Right.
The facts, if I may point out the facts.
Pay protection. Yeah. How old are you now?
I'm 63.
Huh?
I'm retired.
64.
64, 60 years, I've retired.
You retired when? In 2019.
So the issue that pertains to subject to what your lordship might determine, annexure W, your lordship, which is at page page 64.
What have you got? What right have you got for pay protection? Is there any rule?
There's no rule. In fact, what has happened is annexure W may convince your lordship. What has happened is the State Institute of Education, the State Institute of Science Education and Educational Technology Cell, all of these three departments were amalgamated by way of a notification. So when I was initially appointed in the year 1989, I was under the SIE as a project officer, which is equivalent to the post of an assistant director. Then to seek permanence, then those two departments are completely different. Then I joined as a lecturer in 1993, 28/1/1993. Now, my case is that, your lordship, the fact that I moved between two departments which are subsequently amalgamated. And the fact is that
So you want pay protection for which years? Or which year?
pay protection from the year 1993 is the fact that my post, my rank, my pay should have been equivalent to the post which I was drawing.
And
in
you
the
filed this writ petition when?
2020.
For a relief that is paid for to take effect from 93. Delay in latches.
Continuing wrong, your lordship, there is a representation preferred also, again, subject to what your lordship might determine. As per my understanding, the fact that I ought to have been given a higher pay would constitute, in my understanding, would
You
constitute.
cannot, after quarter of a century, more than a quarter of a century, you cannot suddenly jump up and say that, I should have been given this.
So I understand, but
Classic case of Rip Van Winkle, sleeping for 20 years. In fact, more.
the last representations were referred in the year 2015.
Maybe
that is
one.
the last extent of
You see, submission of one representation after the other does not give you a fresh right. It does not start a fresh round of limitation also.
That is my sole case. If the facts are there, I mean, I'll leave it to you.
What is your case? That a merger of so and so, what happened?
What happened was, Your Lordship, that I was appointed as a project officer, which is the rank of an assistant director in the year 1989. 1989. Thereafter, my tenure, it's a temporary post for 3 months, extendable at various intervals with artificial breaks in between. Now, to seek some permanency to my job, I applied the post of a lecturer, which is a rank lower. And thereafter, I've been preferring representations for pay protection for the fact that I had actually come down the scale. Your Lordship would kindly come to page.
Let us see your representations. Your representations are
Your Lordship, the starts at page 67.
page
67, Your Lordship.
67.
It is 6th of June 2015.
New assignment. Show me your right. What is your right to pay protection?
My right, Your Lordship would kindly come to page 23. Page 23.
Page 23.
Your Lordship sees the second table, project level cell.
No, I'm not on this. I'm not on that. I want to show me the law. Where is the right to pay protection?
I'd actually jumped across to two different appointments,
Huh?
so I did not, maybe it's.
You jump from one organization to another.
I'm imploring Your Lordships for.
Huh?
I'm imploring Your Lordship for grant of.
No, you see, we cannot give whatever we want just like that. We have to give as per the law. And then you also have to apply for something benefits in terms of your right. You cannot say that I like that mango in my neighbor's garden, and so go and pluck it for me. That cannot be done. If you say that this is my garden, this is my mango tree, and that fellow is stealing it from me, please take it back from him. That's a different thing. Now out there you want pay protection. Okay, we'll grant you pay protection, but under what law can I grant you pay protection?
If I may just try to take Your Lordship's attention to paragraph 8. There's one submission I've made, which is substantiated by the last annexure. That what had happened is, Your Lordship, after
Page?
page 8, paragraph 8.
Page 8. Yes.
That the petitioner, as may be deemed relevant by this honorable court, state that one Sri Lakshminarayan Honuwal subsequently was appointed as an assistant director on 6/1/1990. Now, assistant director is similar to the post of a project officer. 1990 is after the initial appointment of the petitioner. That is one fact. Now, what has happened is, Your Lordship,
They have been appointed, so what?
subsequent juniors after the amalgamation, because there were certain section who did not jump ship. like the petitioner.
Ah.
They stayed in the
Correct.
earlier
So-
organization, and for parity of their services, the government had regularized their services and amalgamated them by way of the notification that was before your lordship. Now, those juniors, admitted juniors in the same organization, holding a post which was initially held by the petitioner, thereafter, since the petitioner jumped, your lordship, the pay of the juniors were significantly higher.
Because they remained.
Because, they-
On
yes, that is
Ah.
the reason.
You ran after greener pastures. Unfortunately, you lost out.
Yes.
But well, I don't mind helping you, but
the
show me
law-
the way.
Yes, your lordship, I think the law has to also,
Show me the way. We cannot do as we like.
I would pray for one accommodation. I'll just look up at case laws, if at all relevant to the facts at hand, because I tried to, your lordship, things are.
There's none. There's none.
I tried to.
There's none.
But these are the-
Not in the manner you have put your case. Pay protection can be given by the state. Unless you can show that the case of discrimination has been made out. There's nothing here. There's no point wasting time. Right. So you want to pass the order.
I'll leave it to your lordship, but
Okay, I'll pass. There's no problem. I can do it either way. Heard, Mr. M. Sharma, learned counsel for the petitioner. Also heard, Mr. Who appears? Mr. P.K. Bora appears for respondent number 1, 2, and 3. That's all? Mr. S. Bora appears for respondent number 4. Anybody else?
responsible for.
Accountant General will be Mr. Who's that? The one, C. Bora, yes. Yes. I was thinking of the candidate. Yes, any submission, Mr. Bora?
Yes.
Anything to say?
He has come so late, Mal.
Only that? Any other thing?
He has already superannuated from the service, man.
Number 2, then anything?
And my lord. And
Okay.
his representation of in the year 2015.
Okay, right. The petitioner, by way of this writ petition, has prayed for a direction to be issued to the respondent authorities to fix the scale of pay of the petitioner in the pay scale of rupees 2555-4600 per month with effect from 11/2/1993 as was applicable to the post of project officer, EOSC, when appointed to the post of lecturer SCR. The petitioner's case is that the petitioner was initially appointed as project officer of the environmental orientation to school education, not offer. Project officer of environmental orientation to school education, bracket EOSC, attached to the State Institute of Education, bracket SIE, Jorhat, now bracket now renamed as SCRT, Jorhat campus. on 15/12/1989, in the scale of pay of rupees 1200 -2050. He joined the post of project officer EOSC on 22/12/1989. Thereafter, the petitioner joined a new assignment as lecturer of SIE, State Institute of Education, in the scale of pay of rupees 2275/80/2395-80/125-125-4450 per month, plus allowances. Next para. As the that when the petitioner joined the post of lecturer SIE, the pay scale of the project officer EOSC was 255-80-285-100-3575-125-150-150-4600 per month. Full stop. As the pay scale of project EOSC was higher than the pay scale given to lecturer SIE, the petitioner, no, the state respondent took an initiative for fixing the pay scale of project officer EOSC. For fixing the pay scale of lecturer SIE, similar to the pay scale of project officer EOSC. Correct? However, the same has not seen the light of day. Next para, the petitioner's counsel submits that due to the petitioner having jumped ship and taken up a new posting in a different organization, the petitioner was given was being given a lower pay scale than what had been previously enjoyed by the petitioner in the earlier organization. However,
Your lordship may also refer to annexure number W. Annexure
page
64, your lordship,
64.
which had amalgamated.
However, while notification dated 30/01/2003 issued by the Government of Assam, Education bracket Elementary Education Department. The SI, Jorhat, the State Institute of Science Education, SISE, Guwahati, and the Educational Technology Cell, bracket ET Cell, were amalgamated. The next para, the Petitioners Council submits that the petitioners' colleagues who remained as project officer under the EOSC are now enjoying a higher pay scale than the petitioner in the amalgamated organization due to the petitioner having gone to a different organization prior to amalgamation of the three organizations, where the pay scale of a lecturer SI was less than, had become less than the pay scale of a project officer of the EOSC. The petitioners council, this para, petitioners council, thus praised that the petitioner's pay scale that had been enjoyed by him prior to his appointment as that had been enjoyed by him as project officer EOSC should be protected, should have been protected at the time he joined as lecturer SI on 11/2/1993. That's your case. Mr. R.P. Bora, the learned counsel for the Elementary Education Department, submits that the writ petition suffers from delay and laches. He also submits that the petitioner has retired from service on 18/12/2019. Any other thing? What is the third point?
He should have come earlier, my lord.
That's what I've said, delay and laches.
That's all.
That's all.
Initially, they have filed representation to protection is pay, my lord.
Huh?
He has filed it, my lord.
Yes, for pay protection.
My lord.
He wants pay protection
Since
from 1993.
1993, my lord, he is demanding that. My lord, he has
Actually,
come-
he made a mistake. He jumped ship, then the other ship got a new coat of paint. So his ship now is
Lordship is aware what is happening in 3F nowadays in the state.
what?
There's no surety of any job and regularization, even now. So the petitioner at that point in time did the right thing. The subsequent event of amalgamation has now put the admitted juniors on a higher pay scale. That is my grievance. That is the only grievance I had. If the departments were similar, separated, then I may not have had such a case before this honorable court. But now my admitted juniors.
You took a risk. You took a risk. Right? You took a risk. Made a mistake.
And not have been a mistake, but
What to do? Happens. Right.
can kindly point out the contents of paragraph number 8, that it is also my submission that
Para number 8.
that my admitted juniors after amalgamation have been continuing to draw substantially higher.
That's what I said.
Yes, yes,
That's why.
yes, I apologize.
That's what I said, because, yeah,
Yes, that is,
because their pay became subsequently higher
yes,
after you jump ship.
after, yes, the
Yeah,
amalgamation.
after you jump ship. No, after amalgamation, after you jump ship.
No, after
After amalgamation, it became higher.
earlier, the pay was higher, but then there were separate organization, separate department. But now, once under the same roof, post 2001.
Do you have the same, are you all equivalent?
Yes,
Are you equivalent posts?
yes,
Doing the same job? Huh?
separate departments, separate wings. In the education
Separate-
department, there's separate. In
separate-
fact, the first post of a project officer, as I understand, was a scheme by the Assam government. Thereafter, the scheme continued, and eventually, because of
And amalgamation occurred when?
uh,
2003, one.
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 30,
And you filed this writ petition in 2020.
but there have been representations there.
And then that is also after you retired.
Yes, yes.
Okay. If you had filed before retirement, maybe would have considered sending it to the government for consideration, but
There was some communication from the deputy secretary also, which is a part of the annexures.
there was an
There was an
initiative,
initiation, but nothing.
it was initiated, but nothing happened.
happened.
Okay, right. I have heard the learned counsels for the parties. As can be seen from the submissions made by the counsels for the parties, the petitioner is aggrieved with the fact that after amalgamation of the three organizations in the year 2001, the pay scale of the petitioner's colleagues, earlier colleagues in the OESE, is it?
EOS.
EOSE, are now getting a higher pay scale than the petitioner, who had gone into another organization, that is SI Jorhat. Gustav. There is nothing shown by the petitioner as to how his pay that he had been getting as project officer EOSE prior to his leaving the organization and joining another organization, that is SI Jorhat, in the year 1993, could be protected. Post up. The above being said, the amalgamation of the three organizations having been done in the year 2001.
Three. I apologize.
Three. The
Annexures.
petitioner has prayed for pay protection pertaining to the year 1993 only after his retirement. That is full stop. Only after his retirement, full stop. The petitioner retired from service on 18/12/2019, while the writ petition has been filed on 19/12/2019. Full stop. In view of the above, this court finds that there is delay in laches in filing the petition. Besides, there being nothing to show that any right of the petitioner has been violated by the state respondents in not giving the petitioner pay protection with effect from 11/2/1993, when the petitioner had left the EOSC and join the SI Jorhat. Full stop. On considering all the above grounds, this court does not, considering all the above reasons, this court does not find any ground to exercise its discretion in the present case. The writ petition is accordingly dismissed. Next.
Okay, Mr. Angus Council is out of station.
Huh?
Angus Council out of station, Lordship. Matter
Out of station. Who is the engaged counsel?
Yes.
Huh? What is his name? You don't even know his name.
Yes, gas, Lordship.
Huh?
It's reflected in gas. Gas would be. Yes.
Mr. Gias, okay. GIAS.
Yeah, yeah.
Adjournment prayer has been made on behalf of Mr. GIAS, Learned Counsel for the petitioner, who is apparently out of station. The petitioner has prayed for provincializing the petitioner's school. On the other hand, the affidavit of the respondent number 3 is to the effect that the petitioner's school is not found in the DIAS data maintained by the NEUPA, correct? NE.
University of Planning.
NUEAPA. New Delhi. And neither has there been any application for allotment of a DIAS code being made by the petitioner's school to the SSA. Yes, are you filing any affidavit? Any other thing? That's all. 2 affidavits. What to do? They want time. Okay, list the matter on 5th May. 5/5. No further, no adjournment will be given on that date. You've got no case. Zilch, 0. Yes.
Here, Lordship, the service of the petitioners have already been provincialized under the 2017 Act.
Prior to the school being provincialized.
Lordship, so Lordship, the order issued on 4th of January. This is actually should be 4th of February 2021.
Huh?
And effect
It
of
should be what? It should be
4th of February 2021.
still,
If you Lordship, kindly,
even if it's February,
Lordship,
the school was provincialized in August. How is it possible that
Yes.
your services are provincialized, the school is provincialized later
cannot
on?
be. There may be some mistake, Lordship. Our case is that once the schools fulfill or the provisions laid down under section 3 and 4, and the recommendation made by all the scrutiny committee, accordingly, Lordship, their service has been provincialized. But while issuing this order on 4th of January,
Yes, who is appearing?
Lordship,
So the
Yes, who's appearing?
basic issue is, my lord, that the effect of provincialization has been given from the date after the issuance of the order. Now, to extend the legal scrutiny, my lord, section 4, your lordship will kindly see. In the page 114. 114.
Yes.
Subject to fulfillment of all other provisions of this act, the services of teachers and tutors of all venture educational institutions eligible under section 3 shall be deemed to have been provincialized on the date of publication of the provincialization order by notification in the official gazette. So the once the gazette is published, my lord, the provincialization effect will have to be from the date of publication.
That is why in other schools.
So it will be from the date the school was provincialized or what?
The date when the here, my lord, under the 2017 Act, school is not provincialized. It is the service of the teachers.
Okay, this is under the thing.
2007.
So it will be from the date they were
From the date
provincialized.
1st of January 2021.
First of?
1st of January.
You just said
2021.
February, there was a mistake. Why you now
No,
saying?
no. In respect of while lordship government issuing the provincialization order in terms of the government decision of 3rd of February 2021, the effect in respect of all the ME school or high school, the given lordship from the date of.
Have you
1st of
filed
February-
affidavit?
No.
1st of January 2021.
I think they should
that-
file affidavit.
At least lordship from this date also, 4th of January 2021, from the date of notification of this provincialization order, the effect should be good. That is why I have submitted that there is some clerical or typographical mistake. Instead of.
So,
1st
so
of-
to be doubly sure and so that we don't make a mistake, maybe they should clarify.
Yes, lordship,
Can I?
because
Let them file.
Basically, that
already
gazette, date of gazette notification would be relevant.
So please put it in black and white.
so already 4 years has gone by. This
No.
2021.
Oh, what to do? Yes.
Lordship,
Or you
yeah.
can
at least
clarify, my lord,
in
Huh?
view of this-
directing the authorities to give the effect from the date when the publication has been.
Yes, for
In that
section
section
4.
4.
Page?
Page 114, 114.
114.
One.
Section 4, lordship.
Section 4.
So when was it published in the Gazette?
From the contents of the letter, my lord, it appears, my lord, 3rd of February 2021, the government of Assam,
Page?
my lord,
Page
page
29,
29, the order, my lord, impugn order.
My God, I can't read. How do you? I can't read.
Page 29. lordship.
Yes, come in. You
May I
will.
read, lordship?
You try. You read from my copy. You read from my copy.
Not clear. Yes, lord. In pursuance of the letter number so and so, 3rd of February 2021, and the letter number AAC letter so and so, Government of Assam, and in accordance with the provisions contained in the Assam Education Provincial Service Teachers Reorganization of Educational Institution Act 2017, amended in 2018, and the Assam Education Provincialization of Service of Non-Teaching Staff of Venture Education Institution 2018, Governor of Assam pleased to provincialize the service of teachers, of public tutors, and non-teaching staff of the Ajara Someshwar High School District so and so with effect from the 1st of August 2021.
But when was it published in the Gazette?
This was actually published on 4th of January. Actually, that is my first submission is that because this notification is issued in terms of the government letter dated 3rd of February 2021. In
It appears
respect
to
of
be a
other
typographical
schools,
mistake.
Huh?
It appears to be because the order of approval by the government is of 3rd of February
3rd of February.
2021. So the appointment cannot be of 4th January 2021.
But in other schools, this order was issued on 4th of February. After issuance of this letter or in compliance of 3rd of
I
February.
just want a better copy of the page.
Lordship may have-
Oh, your copy is readable, huh?
No, not really. Slightly.
Fifth of February, বাকি বিলাকো ওলাইছিলে। So, 5th of February. 4th of February notification খন হৈছিলে।
Slightly better. No, but then what about this? But then the provincialization of the school took place later on. Can it be done that way?
No.
You see, the school was provincialized in August, while they were provincialized in January. How can it be? Is it possible?
The date of effect is date of effect in respect of.
Date of
the-
effect of what? Of the school?
The school, not school means the teachers who are working, the teaching staff of the.
The post which were provincialized in page 30, Miller.
Page 30.
Page 30.
Page 30.
These are the teachers, Miller, who were provincialized. These are the tutors who were provincialized.
Your copy is better, my dear man. Huh. Yes.
Teaching non-teaching.
Tutors and the non-teaching staff.
Correct. So school, they
Basically, the effect of provincialization has been given
First
later
of-
than the date of issuance of the order.
That can, this should be 1st of January 2021.
where is this impugned order?
It's page 29.
Page 29 and it's at 3.
29 is not the impugned order.
Page 29. The
Yes.
provincialization.
No, he's praying for setting aside the affected date of
Effective
provincialization.
date of provincialization.
Where do you get this affected date?
Effective date in the first paragraph with effect from 1st August 2021. Well, in first paragraph, you're logical. The governor of Assam pleased to provincialize the services of the teachers, tutors of non-teaching staff of the Azara so and so with effect from. 1st
Which
August-
page? Which page?
Page 29.
22.
29.
29. First paragraph on top. Governor has,
Yes,
yes.
yes. The
Okay,
line starts from
yes.
Perhaps in terms of section 4, Miller, it cannot be. No, to be fair, Miller. Because section 4 says the effect, they will be deemed to be employees under the state government from the date the gazette notification is published.
Correct. Heard, Mr. A. Dekha, Learned counsel for the petitioner. Petitioners. Also heard Mr. B. Kaushik, Learned counsel for the secondary education department. And Mr. P. Saikia for. That's point number 4. The petitioners claim to have been provincialized by notification by order dated 4/1/2021 issued by the Director Secondary Education, SM. With effect from 1/8/2021. Correct?
Well,
Full stop. The petitioner's, next paragraph, the petitioner's counsel submits that no, actually, this is a grievance, actually.
that is,
They don't say the claim of the petitioner, they say the grievance of the petitioner is that, huh? Is that the petitioners have been provincialized by notification dated by order dated 4/1/2021, huh? With effect from so and so, huh? 1/8/2021. So, the petitioner's counsel submits that in terms of section 4 of the Assam Education Provincialization, the 2017 Act, here and after referred to as 2079, comma. The services of the teachers and / or tutors of all venture educational institutions eligible under section 3 are to be deemed to have been provincialized on the date of publication of the provincialized order by notification in the official gazette, and they become employees of the state government with effect from such a date. Full stop. Next paragraph. In the present case, there is nothing to show as to when the official gazette notification had been made in respect of the order dated 4/1/2021. Full stop. Next paragraph. Mr. B. Kaushik, what do? I send it to the director or what?
Malad can send it to the director.
Huh?
They will give the effect from the date of the original publication.
Mr. B. Kaushik, the learned counsel for the Secondary Education Department, submits that.
Lordship, kindly come to page 26 Annex 2.
26.
Before passing the issuance of this order, the government issued this instruction as to when the provincial order will be issued. Annex 2, page 26. From the director, from the government lordship to the director lordship. May I read lordship?
From the government to.
This was issued 27 January 2021.
Huh?
With reference to the subject cited above, I am directed to state that as per discussion taken in the review meetings chaired by Honorable Minister so-and-so 26 January on the process of appointment letters to the graduate teachers. Second one, the provincialization order to schools, incumbent and drop teacher, the revised schedule as mentioned below. Ceremonial distribution of appointment letters to the selected gazette teacher. This is not for us, lordship. Second, lordship, all selected candidates from districts and selected provincialized incumbents
should attend the ceremonial function.
Yes.
So?
The 29th January, district-wise provincialization order issued on 29th January as per the appropriate sent from the government. Now, director, secondary and inspector assisted by computer supports must finalize merit list 30th January 2021 without fail. As the inspector of school of 21 districts should undertake the physical verification of testimonial of the selected.
How does this help you? How does this help you?
Regarding the date of lordship, this.
The law says that the official gazette is required.
Completed.
Then this is of some secretary to the government. He's not bound. He's above the.
Page 27. Appointment letters and incumbent will be distributed from the date and count on 5th of February.
So what?
So at least lordship, from that date, lordship, we are entitled, lordship.
No. Sorry. When the law says.
Of the date of publication.
Then.
I also am benefited, then it was issued on the month of January 2021.
No. January 21 is the date of issuing the appointment order. The
You see, the real effect, the actual effect.
Effect is even 1st of August.
Sorry, the effect is as per the law. The law provides that it has to be published in the official gazette. Then only.
If it is published on 4th of January. then
Ah,
it is on 4th of
it says here, on the date that it is published, from that date it will take effect.
Which,
He might say anything. He might say that once we give you this appointment order, you'll be deemed to have been provincialized from 2 years back also. He might say that. How do you know? Will that have any bearing on the issue? No, the law says that this is how it has to be done.
Date of
Has to be calculated. How can you say otherwise? Right. So what have I said? Submits that the issue of when the effective date of provincialization of the petitioners is to be calculated should be sent to the director of secondary education, who will take a decision on the same in terms of section 4 of the 2017 Act. Stop. Next para, huh? Mr. A. Dekha, learned counsel for the petitioner, submits that he has got no objection to the proposal made by Mr. B. Kaushik. Stop. Next. I have heard the learned counsels for the parties. Section 4 1. I think 4.1 is enough. है ना?
4-1 there.
Section 4.1 of the 2017 Act states as follows. Stop. Next para. A reading of the above clearly goes to show that the services of teachers / tutors is deemed to be provincialized on the date of publication of the provincialization order in the official gazette. Accordingly, the Director of Secondary Education shall take a call on when the effective date of provincialization of the petitioners would take effect in terms of Section 4 of the 2017 Act.
After verification of the gazette.
Huh?
After verification of the gazette.
Which should be done, which should be done after verifying the same in the official gazette.
Right.
The entire process should be completed within a period of 2 weeks from the date of receipt of a certified copy of this order. The writ petition is accordingly disposed of. That's all.
Right. 26.
May I please, your Lordship? Lordship, I am appearing on behalf of Mr. K. Singha for the petitioner. The file relating to this matter has been misplaced, so your Lordship kindly adjourn the matter for the day. Fix another date after view vacation.
Yes, Mr. Kaushik, you still have got a job to do. Your affidavit.
Here we are still awaiting instruction.
Okay, right. Adjournment prayer has been made on behalf of Mr. K. Singha on the ground that he has misplaced the case record. No, his brief. He said. Mr. B. Kaushik is granted 4 weeks time to obtain instructions and file affidavit. List them out after 4 weeks.
May I please? Also, last occasion, what is CBSE shall produce the petitioner date of birth,
List of candidate,
Lordship.
Lordship.
16/9/2000.
The list of candidate, Lordship, the
Just a minute.
nothing, no? Is it?
Yes.
Lordship, this is the Lordship list of date sent by the school. It is mentioned as 16/9/2000. And this is the copy original, Lordship. Lordship, I see that here that is a parent signature, the student signature is also.
Okay, it is there. Yes. What are you doing then?
Sir, I have prepared an agreement, in the.
Last
thing.
week.
So sometime you done.
It appears that your client is trying to fool this court. Hmm? Ah, the last time you gave a different document.
No, I've given the document, the decision of the.
Another thing, Mr. Counsel, you see, your entire case is on the basis of a birth certificate issued by the director. Correct? Let us see your birth certificate. Page. Where is that?
Page,
Page 16.
page 16.
Page 16. Page 16. Page 16. Oh, we do not know who.
Yes, no, it's not visible. The original certificate. they have.
No, there was another thing. There was another document submitted.
Yes.
No?
It's the original Lordship they have got. Original one.
Who has issued this? We don't know.
No, no signature is there, no seal is there, Lordship.
Even the character certificate of the school, it
Ah.
is signed by principal,
Ah.
your lordship. Lordship, the character certificate from the school, lordship.
Director certificate? Character certificate.
Lordship, the next bit. From the,
These schools, so they will write anything. You see, okay, next to right.
Lordship, one thing is there, Lordship, as per the the registration of Birth and Death Act 1969, that delayed, section 13, Lordship says delayed registration of birth and death, section 13C, 3. Any birth or date of which delayed information is given to the registrar after 1 year of its occurrence shall be registered only on an order made by a district magistrate or subdivisional magistrate or by an executive magistrate authorized by the district magistrate having jurisdiction over the area where the birth or death has taken place. After verifying the occurrence, correctness of the birth or death or on payment of such fee as may be prescribed. This is, I have taken the course. 13.3.
Any birth or death of it is given by. No, that is all right, but this one out here is 2003. When was it issued? We do not.
We don't know that is
date
mentioned.
of registration is there, lordship.
No, date of registration, when was it issued?
Issued, lordship.
When was it issued? Date of registration. You see, you might ask it's like this. You ask for a certified copy. Your date for asking for a certified copy will be given. But when it was issued to you, that's a different date. Date of registration doesn't mean that's the date of issue of the certificate. When you ask for a license, say a gun license or gas license or whatever, you'll make an application, there'll be a date, it'll be registered with the authority. Then they will issue the license. When it will be issued, that's a different date. Registration date is different. It's very unlikely that you'll get a certificate in India on the day you apply for it. Very unlikely.
And signature issuing authority is also not, no seal is there.
Correct. Anyway, this,
No designation, nothing.
this does not seem to be attracted as on date, because when they had applied for it, it appears that they applied for it in the year he was born, 2003.
But it should be corrected.
Anyway, right. So where out here, what were you saying out here, madam?
Lordship, that this is the copy sent by the school, list of candidates,
Yes,
list of LOC.
16/9/2000. Oh,
Yes,
okay,
it is
okay.
written
Right.
16/9/2000.
Let,
And his
let it-
signature is there, his parent's signature is also there.
Well,
The
let it be come in the
okay.
record.
last
Why
page,
don't you file affidavit?
Let them find the affidavit, let them take their
I
stand.
It is
last
clear.
page, Lordship,
Last
last page,
page.
yes. This is the copy online they have sent. This is the last copy is from original.
Okay, their
record.
signature. You brought
Yes.
this from your record.
Oh, record, Lordship. Because
These are
their
records.
parents.
Give a copy. Then you don't have a right to ask for that. You can give a copy of that.
Signature, parent signature is also there. They have said that this is the right date. Lordship. এই তো। Mark Buffett, Laura signatures.
At least, Lordship, let them bring this document on record.
This is the attested copy, Lordship, by the department. The department.
Can you bring the official, you can bring the records.
This is the Lordship, this is the attested copy, they have attested.
This is
CBSE have,
where is the original seal?
original is with the school authority.
It is
They have-
school authority. They have submitted this.
Yes, they have submitted as this one. They never produced the original ones.
They have not produced.
No.
Yes, that's true.
On several occasions, we have requested that this petition also, they have never produced the original birth certificate, nothing.
Original birth certificate, Lordship, they have produced.
No, CBSE, they never received, Lordship, as per my instruction. And that's why the CBSE wrote to the school authority to give the original birth certificate.
No, original is not with this school.
Maybe school was requested to ask the student.
The certificate is.
The other day, you brought some other document showing a different
That
date.
was a document that the school register, when they were written. The register I had given, the copy is in the file. The register where the school,
Y'all are very good at making up I don't know, particulars, I think.
we are very clean.
Huh?
We are very clean. That happened.
I don't know whether you're clean.
When the CBSE source on all documents, we have provided all documents.
You see, the documents that you have produced clearly shows
yes,
that he 2000.
2000.
2000.
Later on, they have written.
Yes.
How they can write?
May 719. Because the application that is made, the format, they are everything written, how the mistake happened. So the application is there with the file for the CBSE regional officer, and in their explanation is given.
Maybe call for it.
How it is, how it is wrong the record.
I mean, attested
And only on that occasion, my lord will
post
teach you
document diya na.
or that there is a provision of correction. Now, if a wrong entry is made there, there is a provision of correction, and as per that rule, the petition is asking for that. And we have forwarded the application on the 29th February 2020.
You see, the reason why the school records are not given that much importance, but the matriculation certificate given by the board is given more importance is because number of times it has been noticed that you all have fabricated documents. Particulars.
The application, what I submitted is that, my lord. I have got this the application for the admission and
Okay, right. Miss R. Bora, Learned Standing Council, CBSE. has submitted, has submitted copy of the
List of candidates.
list of
Candidates.
candidates submitted by the school
School page.
who are to participate in the matriculation exam. And the same shows and the same includes the name of the petitioner, wherein his date of birth has been recorded as 16/09/2000. The certificate that has been submitted by the school to the CBSE also shows that the particulars of the petitioner regarding his regarding particulars of the petitioner, including his date of birth, date showing 16/9/2000, has been signed by the petitioner's father, the petitioner's mother, and the petitioner himself. Yes, sir. You file a short affidavit, madam, we just annexing this, okay?
Yes, okay.
Miss R. Bora is granted a week's time, 10 days format.
You will come after.
Yes, but we file it before Bihu.
Before you will file out.
Is granted
Next
a
week.
week's time. A week's time to file affidavit
Yes.
showing and annexing the list of students that has been submitted today to this court. Mr.
MK Mazumdar.
M.K. Mazumdar, the learned counsel for the respondent number 4. Submit that he will file affidavit within
2 days.
within 2 days. List the matter
11.
on list the matter as part heard on 6/5.
6/5.
Public. Very good.
Online.
With legal office, last occasion they took time for.
My lord, in this matter, I have received the instruction from the IS, but my lord, it is not sufficient as because he has sent the arrear salary proposal to the DSC, my lord. So now what is the status?
DSC?
I have to take instruction
DSC?
regarding,
D?
means IS, my lord.
IS has sent to
Inspector of
whom?
School, to DSC, the Director of Secondary Education. So now I have to.
Yes,
take
send the arrear
instruction.
proposal.
Yes.
Forwarding letter dated
Forwarding letter dated, my lord, MDC arrear salary 2023-24.
Date.
Dated 17/8/2024. This is my instruction.
17 August.
17 August
Okay, right.
2024.
24.
Mr. U.
You, Sharma.
Sharma, learned counsel for the Secondary Education Department, submits that as per instructions received by him, the inspector of schools has sent the area proposal amounting to rupees 22,30,317 to the Director of Elementary Education.
Secondary Education Department.
How do you say elementary?
No, my lord, at the
Uh,
first
the
time it is
Director
elementary,
of
after March
Secondary
20
Education Department on
on at last 17/8/2024.
17/8/2024.
Yes.
He shall accordingly get the up-to-date status with regard to the same. This is the matter on when?
23, my lord. With this date,
23 of April.
April. Oh. Put the earlier one.
25.
Earlier one.
My lord, this petition was received.
Yes, what is happening?
Kindly, pass over the matter for the time being here, my lord, the big Kaushik will appear, my lord.
And my lord, there is a contempt
Yes,
pending because
contempt
provisional
proceeding.
pension is directed to, for the last 14 months, no pennies.
So contempt
Let's
is
wait.
dealing with the, by.
This.
Or this is similar to a case my lordship had disposed of last week, my lord. Same college, same advertisement, my lord.
I don't remember.
My lord, I will share. Just that in this case, the director has approved the appointment. So your lordship wanted to produce the records. The records from the director's office. The person with the highest marks was not selected. A person with much lower marks was selected, and he was sent for approval by the director. In this case, the director has approved the selection.
It's for the same college,
Same college, same advertisement.
same post.
Same post, but different category, reserved category member. This is OBC category.
OBC. Outside was the SC category.
Yes, ma'am.
Okay, I'll just, yes.
Your Honor, I am appearing for the respondent number 3, 5, and 6. And the respondent, and during that time, I was not in that post, principal secretary. Principal and
Same thing,
secretary.
same thing.
And one point to be noted, in the respondent number 7, Your Honor, he has been already, has been discharging his duties, and I have been enclosing my annexure. So
He's been discharging his duties?
Since he was,
Since
he
he's
was
working,
appointed, my
he was appointed on 10, 2000
Appointed as what?
as a
junior
junior assistant.
assistant. Great.
And I have enclosed the annexure B and C.
He was selected and appointed, my lord. In this case, only selected, but not, the director did not approve it.
Out here, he has been selected and appointed.
Lord.
Yes, sir.
That is point number 7.
Lord.
Then that has to be set aside.
Lord.
Yes,
It has to be set aside. Because, so if he's less marks, then what remains?
and he is not present.
And he's not present.
Who is he?
Referendum
7.
EFA?
I'm 3, 5, and
College.
6.
Yes.
College.
Okay, right. So we'll copy ditto. Right. Heard Mr. S. Day, learned counsel for the petitioner. Mrs. S. Khatania,
Yes.
learned counsel, appears for the respondents number 3, 5, and 6. While Mr.
Yes, yeah,
S. Bhuya appears for
1 and 2 also.
respondents number 1 and 2.
Sitting a higher degree.
No one appears for the respondent numbers 4 and 7. Correct?
Lord, sir.
4 and 7. Good stuff. As for the order dated 24/1/25 passed by this court, the notice upon the respondent number 7 is deemed to be complete. Good stuff. Next paragraph. This selection, this is the same date.
Yes, ma'am.
Okay, so item 2 is same. Para 2 of this order is same. Junior assistant, no? Correct.
Yes, my lord. Under the OBC category.
And then instead of the scheduled caste category, you say OBC category. Okay. Person to the advertisement, that is same. Petitioners here, person that for the post junior assistant, grade 3, under instead of SC category, OBC category. Okay. Then the person communication also same, 18 May. Mr.
My lord.
Is it the same? This 18th May 2017 communication.
My lord is Reading which para?
Para 3.
Advertisement, yes,
No.
but yes, my lord, the process for selection was made in terms of.
Para
Yes, yes,
4,
yes,
para,
yes, my lord,
para
yes.
3, the last
Yes, yes.
18 May
yes,
2000,
yes,
same.
my lord, same.
Then next para 4. It is the case of the petitioner that in the selection, in the said selection, comma, the petitioner obtained how much?
60.993.
60.993 total marks. And the respondent number 7 obtained
43.951.
43.951 total marks under the OBC category. Everything will be the same. So for how much did you say? 43.951
951.
and you are
I am 60.993.
60.99. Okay. Then para 5 is the same, para 6 is the same. Para 7 is the same. Then para 8 is the same except the marks will be different. Okay. Marks will be different. 8, 9, 10 same. Okay, that's all. 8, 9, 10, 11 same.
Lordship, here there is an appointment order that is.
Okay. Acha, out here in para 10, consequently, the appointment of the appointment order dated
5/10/2023.
5/10/23, appointing the respondent number 7 as junior assistant
Lordship.
is hereby set aside. Acha, wait, in the beginning also we'll have to put it, I think. In para 2, now you put one more thing. The petitioner is also prayed for setting aside the appointment order dated so appointing the petitioner junior as junior assistant pursuant to the selection process held in relation to the advertisement dated 15/3/23. Okay. Dispose of.
Lordship, consequently, I have to be appointment here since the appointment is set aside.
That's true. So whatever I said, just give me this.
In that case, your lordship said that the director will decide as regard the appointment of here.
So I will say. Okay. No, accordingly, the response 3 and 5 governing body and principal are directed to forward the name of the present petitioner to the respondent number 2 for approval. Yeah, it's okay. It has to be done. This is now they have to recommend you.
Lordship. Much of that.
In item number 31, Lordship, I am for the respondent number 9, Lordship.
Here the first wife, second wife.
Lordship, allegedly second wife, Lordship. But Lordship, morning Lordship, as I have requested the petitioner's counsel, Lordship, to pray before your Lordship for some time, Lordship. So perhaps.
Yes, the other first wife.
Yes, your lordship, in this matter, they have taken a consent for not doing the matter today. So
You are supposed to produce the original decree. Where is the original decree?
in next date, I will produce your lordship.
Is it? Okay.
I'm very sorry.
No problem.
But I appeal to accounting general and I have express instruction, written instruction that we have no role to play. Therefore, I will pray that our name may be struck off, Lord. Otherwise, keeps on. I'll place the instruction.
Yes. Any objection?
Perhaps.
Why don't you make an application? Why do
Then I'll.
you make an application? Right.
Because, otherwise, Lordship, I am having 3 minor children also, Lordship. So date may kindly be fixed on 30th April, Lordship.
When?
On 30th April.
Okay.
Lordship.
Right. On the prayer, the parties list the matter on 30th April. The petitioner's counsel shall produce the original decree in respect of title suit number 134 of 2012 on the said date.
Right. My lord, here, as per last order, my lord, instruction has not yet received, my lord, and moreover, my lord, department has returned to the senior standing council for his.
You see, it is very simple, this issue. There's nothing difficult.
Yes.
You all are just trying to confuse the issue. You see, now you are saying that because that Mustafa Shahidul Islam has died,
Right, yes.
you do not know whether the appeal filed by him should be uh, considered or not, should be decided or not. Now, when you look at the order, come to the order. Come to the order at page 59. Have you got page 59?
Yes.
What is page 59?
WBC 4477.
Correct. Now, how many writ petitioners? You have got two writ petitioners.
Yes, my lord.
One is the petitioner number one is the school.
Yes.
Represented by Mustafa Shahidul. Second is Mustafa Shahidul. Correct.
Yes.
Now come to the direction passed at page at page 62, para 5. It says here, what does it say? Please read.
In view of above the matter, the petitioners are directed to file an appeal before the state government against the recommendation of the state level scrutiny committee within a period of 10 days from today. Thereafter, state government on consideration of the facts and circumstances of the case shall pass appropriate orders and in accordance with law within a period of 1 month from the date of receipt of the appeal.
Then please read the second part.
Till
Para
such
6.
time, till such time, the state government disposes of the appeal, the respondents are directed not to provincialize the services of the respondent number 6. and
Now,
7.
now you see, it says the petitioners are to file an appeal.
Yes.
Now, when you come, then thereafter the petitioners had filed an appeal. Correct?
Yes.
Petitioners have filed an appeal.
Yes.
So even if that Mustafa had died,
Yes.
the appeal is still there because there are two petitioners. One petitioner is the school. That's all.
Yes.
So you have to decide that. You cannot say that you cannot decide. You have to decide the appeal.
But my lord, the school was represented by the chairman and chairman himself died.
So what?
And
Now
then
there'll be a
Mustafa-
new chairman. There'll be a new chairman. The school may be represented by a chairman. Today, the government of the High Court is represented by a registrar. His name may be ABC. Tomorrow he'll be somewhere else. That person who next come will be XYZ. But the High Court still remains. It's just that the person who represented is different. That's all. How does it matter? What kind of what logic is that?
But no new chairman has come forward to lead the appeal, my lord.
You see, Mr. Kaur, you take a decision on the appeal. Who says that the appeal has to be, once he submits, then you have got to take a decision on that. Please come to the order again. Otherwise, we will call your officer. He doesn't understand. He doesn't understand plain English, Mr. Sharma. Huh? Come to page 62.
Yes, ma'am.
What does it say? Read once more.
Serial number 5.
Yes.
In view of the matter, the petitioners are directed to file an appeal before the state government against the recommendation of the state level scrutiny committee within a period of 10 days from today. Thereafter, state government on consideration of the facts and circumstances of the case shall pass appropriate orders and in accordance with law within a period of 1 month from the date of receipt of the appeal.
That's all. Where does it say that you have got to hear the chairman? It just says that the representation has to be filed. Once it is filed, you take a decision on that. Whatever he has to say, he has said it by way of the appeal. Supposing I ask you, Mr. Sharma, please submit a written argument. You submit a written argument. Do I have to hear you on that written argument?
No.
Then? You cannot go beyond what is said here. You're wasting time. And if you don't decide, I'm going to call this officer
No.
and for contempt of court. What is this trying to circumvent the orders of this court?
Moving on.
A simple thing like this, you are wasting time.
Also, this order has been passed on 22 and they have provincialized other colleague on.
I know,
24.
This is what, this is just wasting time. This is wasting time. Okay, right. Heard Miss
M. Nirola.
M.
Nirola.
Tiro.
Nirola. Mirola.
Nirola. Okay, Miss M. Nirola, learned counsel for the petitioner. Petitioner or petitioners?
Petitioner.
Petitioner. Who is the petitioner?
Lordship, this Jomila, I mean the.
Acha, one of the
One of the.
one of the respondents. Okay. One of the respondents in that. One of the respondents in which? Where?
That this writ petition, Lordship.
Huh?
This 52, page number 59, Lordship.
Hello, the repetition 4477 of 2022.
Yes.
He is
Page number
a serial number 6, Jamil
Six.
Ahmed.
Okay,
Yes,
okay.
This one number
Okay.
6. Lordship.
Right, whatever I said. Writ petitioner and Mr. U. Sharma, learned counsel for the
Yes.
secondary education department. The writ petitioner's grievance is that in terms of the order dated 18/7/2022 passed in WPC 4477/2022, the state government was to take a decision on the appeal filed by the
One side.
Hazi Amsar Ali Mukhtar Girls Secondary Senior Secondary School, represented by the chairman of the governing body of the school management committee, Mr. Mustafa Shahidul Islam. Within a period of 1 month from the date of receipt of the appeal. Till then, till a decision was taken by the state government, the state government was directed not to provincialize the services of the writ petitioner hearing and one Miss MD Tariquel Islam, TARIQUEL, who were the respondents number 6 and 7 in WPC 4477/2022. Next paragraph. The petitioner's case is that the Hazi Amsar Ali Mukhtar Girls Senior Secondary School, represented by Mustafa Shahidul Islam, who were the petitioners number 1 and 2 in WPC 4477/2022, had filed their appeal on
Lordship, there is no record whether they have filed the appeal or not. We have stated in our petition.
No, no.
We don't know whether there is an appeal or not, Lordship.
Okay, okay. But they have said this, there's a,
Appeal has filed on 20/12/2022.
I know, what have I said? No, there is this, the petitioner's case is that they are not, they do not have any proof that the so, 1 and 2 in the writ petition had filed any appeal pursuant to the orders dated 18/7/2022, passed in WPC 4477/2022. As such, the writ petitioner herein has prayed for a direction to the respondent authorities to provincialize the service of the writ petitioner
Because Lordship, my other colleague has services.
in as much as the respondent number 7 in WPC 4477 of 2022 has been provincialized. Huh?
The state recommendation committee who has recommended the name of the staff of the school, they have been provincialized.
Okay, the others.
Where the petitioner name also was.
But the number 7 has been provincialized or not?
Lordship, number
Okay.
7 and the.
Right, in as much as the staff of the other staff of the school, of the said school, sons, sons, the writ petitioner, and the respondent number 7 in WPC 4477 of 2022 have not been provincialized. Correct?
They have provincialized, only our service has not been provincialized.
Correct. 2 of yours have not been provincialized.
Because my lord, the respondent number 6 and 7 were terminated by the principal of the Haji.
Correct. No, that's a
Yes.
different thing. That is her case. I'm just saying nothing. On Mr. U. Sharma, the learned counsel for the secondary education department, on the other hand, submit that in persons to the order dated 18/7/22, passed in WPC 4477 of 2022, the said school through Mustafa Shahidul Islam has submitted an appeal. Correct?
Yes.
On 20/12/2022, not to provincialize the service of the petitioner and the respondent number 7 in WPC 4477/2022 on the ground that their services had been terminated by the principal of the school on the recommendation of the management committee vide orders dated 14/6/2021. And as such, the recommendation by the state level scrutiny committee for provincialization of the services of the writ petition hearing and the respondent number 7 in WPC 4477 of 2022 could not have been done. Full stop. Next para. Mr. U. Sharma, the learned counsel for the secondary education department, further submits that Mustafa Shahidul Islam, who was the chairman of the school managing committee of the school, has expired and as such, and advice has been sought for from
Senior
who?
Standing Council,
From the Senior Standing Council,
Department of School Education.
Department of School Education, Guwahati High Court, as to whether the appeal filed by the school should be disposed of. Full stop. Next para. The order dated 18/7/2022 passed in WPC 4477/2022 states at para 5 and 6 as follows, page 62. Full stop. Next para. The Haji Amsar Ali Mukhtar Girls Senior Secondary School and Mustafa Shahidul Islam are arrayed as the petitioners number 1 and 2, respectively, in WPC 4477/2022. Next para. As the letter number E-275543/112 dated 2/2/2025 issued by the Secretary to the Government of Assam, Department of School Education, has stated that an appeal had been filed on appeal petition had been filed on 20/12/2022 by the late Mustafa Shahidul Islam, it can be implied that the said appeal petition had been filed not only on behalf of Mustafa Shahidul Islam, but also on behalf of the Haji Amsar Ali Mukhtar Girls Senior Secondary School. As such, the Secretary to the Government of Assam Department of School Education will have to take a decision on the said appeal petition dated 20/12/2022 within 30 days from the date of receipt, from today.
From the date of.
No. I'm going to initiate contempt otherwise. This order has been passed. You have received this appeal petition in 22. Full stop. This court list this matter again on today's what day? List this matter on 6/5. 6/5/2024. It is made clear that if the appeal petition dated 20/12/2022, which is reflected in the letter dated 2/2/2025 issued by the Secretary to the Government of Assam Department of School Education, is not disposed of by way of a reasoned order by the next date, the same would amount to deliberate violation of the order dated 18/7/2022 passed in WPC 4477/2022. The letter dated 2/2/2025 issued by the Secretary to Government of Assam Department of School Education is made a part of the record and marked as Annexure X. Flimsy way of not taking a decision. It's very clear. It says the court has said petitioners appeal. Just because the chairman of the school management committee has died, it doesn't mean that the school has not filed the appeal petition.
Copy of order, furnished.
No, it's going to be uploaded. You download it.
Yes.
Timing 29.
So in this case, my lord, in terms of the interim order, my lord, we
29?
in terms of the 29,
pension.
item 29. No, in terms of the interim order passing this petition, my lord, 25/9/2024, the provisional pension ordered, my lord, on 29th of March 2020.
What about the final pension, regular pension?
Now the pension papers has to be uploaded in the Kritagata portal, my lord. It's a portal where the sanctioning authority is the director of pensions. So our responsibility is to upload the document.
Has
which
it
we
been
could not-
uploaded?
No. Which
Who
we could
who is
not
to
do it.
upload?
Which the inspector of school. The order has been done. So it will be uploaded within the day or 2 months.
There is a notification to code. There is a, if there is a self.
Absolutely correct, my lord. Why it is
if
not
there
been
is a-
uploaded, my lord? Let me explain this, my lord. What
if-
happened, my lord? That to upload the pension papers, my lord, there is a requirement of uploading the no liability certificate that is issued by the retiree himself on his individual capacity. Now, my lord, the petitioner, he was suspended, and subsequently when he was reinstated, he was attached to the office of the inspector of school. Now he submitted a no liability certificate issuing as the headmaster of that school. Now that's not an individual capacity. Now, after retirement, the office insisted to give the no liability certificate on his individual capacity, because the circular says that we need not have to wait for the audit report, because the school has not been audited for a long period. And the no liability say, without insisting for the audit report, we can proceed by the no liability certificate that is issued by the petitioner on his individual capacity. But he issued a certificate when he is attached to the inspector of school as an headmaster. Now, anyways, we have relied on that no liability certificate and we have issued the provisional order, pension order. And we'll be submitting the proposal, within a day or two in the Kritagata portal.
The regular pension I'm talking about.
Regular pension, we can do it, it's a director of pension.
But it has to be initiated from you.
Yes,
Then-
the proposal has to be submitted in the Kritagata portal by us, the inspector.
Then
And when
So-
that we are doing it in, we have ordered.
you obtain instructions as to what has been done by the inspector of schools.
That's the provisional pension order already passed.
And the provisional, I'm not bothered. I want the regular pension.
Regular pension, we'll upload the papers within a day or two. We'll upload the papers. That's our only responsibility. Inspector can just upload the papers.
You do that.
Yes.
After due vacation, let me then can.
Huh?
After due vacation.
Let it be after big vacation.
Immediately, then let me be fixed.
Right, Mr. B. Kaushik, Learned Counsel for the Secondary Education Department. Submit that the provisional pension of rupees 35,950 per month with effect from 1/2/24 till the date of finalization of the pension by the Directorate of Pension Assam has been sanctioned to the petitioner via letter dated 29/3/25. This is wrong. You all have, huh? You all have superimposed the top portion. Unfortunately, the signature of the inspector below shows that it is of 1 November 2024. Sure.
Possibly.
No,
Copy
this.
paste.
And the below signature is the one that is usually issued after a memo number is given. And it has been registered in the dispatch register. Trying to mislead the court. I think we'll call this fellow, let him come.
Should it is saying shown, and the inspector signature doesn't bear any date. There is some initial in the down below. I don't know this.
What do you mean? That is the signature,
No,
that is
the
the,
inspector signature is this, my lord.
correct, I see the
And
date there.
down below, there is some initial, my lord, with this date. What you will kindly see.
Okay, 1 year back when I page 20, inspector was.
The inspector
Yes,
signature,
given
you
direction.
will see in the top. There down below, there is some initial, my lord.
Yes.
And that doesn't appear to be the same initial of the inspector.
My lord, the contempt case, my lord.
Just a minute. You also, just a minute. Let me think. I cannot listen to you both and concentrate here. Yes. So what have I said? Full stop. A perusal of the letter, however, indicates that there is a date of 1/11/2024 at the bottom of the said order. Full stop. When are you going to give this provisional pension?
About the not given provisional pension, my lord, it will be given. Your lordship will fix it immediately after vacation. By this time, I think, my lord, it's marked to the letter is also
Right.
marked to the treasury, my lord.
The petitioner having retired on
My lord, one.
retired on 31/1/2024. It is surprising that the petitioner has not been paid provisional pension till date. Mr. B. Kaushik shall obtain instructions as to why the provisional pension has not been paid to the petitioner till today, and as to the status of the regular pension payable to the petitioner. He shall obtain instructions as to whether the inspector of schools has uploaded the proposal for payment of regular pension to the petitioner, which has to be sent to the Directorate of Pension for approval. In the event no action has been taken by the inspector of schools by the next date, the inspector of schools will have to personally appear with all the relevant files to explain why no steps have been taken by him. This is the matter on when?
Just after the.
When? Okay, just after you. This is the matter on 25th. 25th.
25th.
Lord,
There's not some. We'll say no one came.
Lord, I pray for some time to file it.
Item
Item 33. I'm from Guwahati University, Lord.
gratuity.
Yes. Gratuity amount.
Okay, right. Mr. P.J. Fukan, learned Senate Counsel for the Guwahati University, is granted 4 weeks time to file affidavit with regard to the pensionary benefits payable to the petitioner. This is the matter after 4 weeks.
Lordship, here we have issued the compliance order. We have issued an appointment letter and the
Complied
petitioner
with?
It has here joined also, Lordship.
If it's complied with, good.
Lordship,
Mr.
SN
Yes,
SN Padhyapak.
and Mr. S.M.T. Chesky, learned counsel for the,
Respondent number 1, 3, 4, 5, and 7, 8. Lordship.
and Mr. B. Gogoi. For point number 2, submit that the
Joining from SN. And joining also, he has also joined Lordship. He is in Varnacular, Lordship.
submit that the order dated 24/7/18
Yes, Lord.
passed in WPC 584, no, which one, huh? 5847 of
5846.
2016 has been complied with.
134,578.
26/9/19, no, actually, which order has to be complied with?
Well,
26/9/19, 26/9/19, passed in WPC 5847 of 2016 has been complied. Correct? In view of the above, the contempt petition stands closed.
I pay for response number 6, but not 2.
Acha, we be going for response number 6.
So it's a time of minimum.
No, 35.
35 lordship, I am appearing on behalf of the director lordship. The director has already sent a report to the secretary lordship.
Where is your wakalat?
Yeah, we have filed it today.
You filed it?
Yes, yes.
Miss
Because
Tuti
it
has
was
also filed.
It is reflected in the.
Okay.
Yes, that was, I have seen.
Yes, okay. So,
So now.
this is not payment of salary.
Yes, now the direction was there whether the petitioner was, that petitioner lawsuit will be allowed to continue in the lawsuit.
Lordship, kindly have a look at page 13, paragraph 11, Lordship. Specific direction for paying the arrear salary of a specific period, Lordship.
Arrear salary.
Yes, director has stated that the petitioner is similarly situated along with the petition of retable number 211 of 2019 and accordingly written to the government lawsuit for its approval lawsuit.
Similarly situated, so comply.
Yes, comply. Only the order is to be, approval is to be given from the government lawsuit. Thereafter it will be.
Okay, right. Mr. SMT Chishti has submitted letter number E-42091/170 dated 19/3/25 issued by the Secretary to the Government of Assam, Department of School Education, which is to the effect that the directors of secondary education, or what is this? Secondary education has furnished his views on 11/3/2025, stating that the petitioner was similarly situated with the petitioner in WA number 211/2019. He accordingly submits that order for payment of arrears salary will be made by the petitioner. Correct?
Yes.
Leaves the matter after
4 weeks. Okay.
4 weeks.
Yes.
Date may be given.
Your date.
36 to 46, we have already issued a compliance order lawsuit. Lawsuit may kindly direction in the page 37, paragraph 15, the direction of this honorable court. And accordingly, we have issued the compliance.
Have you got it, madam?
Yes, I have.
Lordship, I received the complaints.
All the copies.
But Lordship, I would like to point out one thing,
Huh?
Lordship. I would like to point out one thing, Lordship. Lordship, in the judgment, Lordship, in paragraph 15, Lordship, page number.
Page?
Page 27.
Lordship is taking which?
Page
This
27.
is 24, 36,
24.
Page 27.
item 36,
Lordship, in paragraph 15, Lordship of the order, Lordship.
paragraph 15. Yes,
Lordship, 3 observations were given, Lordship. Firstly, to give a notice, which has been
where,
complied.
where?
Lordship,
Under such circumstances.
yes, Lordship, the government is now required to examine and pass a speaking order in respect of each of these petitioners. If the order provincialized was issued on the basis of correct documents, wherein it is reflected that the subject concurrence was received after 1/1/2006, in the event the government takes a decision that the provincializations are to be cancelled,
then the petitioners will have to put to a proper notice before such cancellation orders are to be issued. Lordship, we have received the notice, Lordship. Now, after filing the contempt, Lordship, Lordship, please to come to the same paragraph last line, Lordship. In the event the department finds that the provincialization is in contravention to
Just a minute, then it says the respondents cannot rely upon
Clause 5 or
clause 5 of the order to arrive at a conclusion
that the order of provincialization of petitions.
in the event, yes.
Lordship,
In the event the department finds that the provincialization
contravention
is
with
in
the provision of the
contravention
Act.
with the provisions of the
and
Act.
the school management authority will be directed to pay salaries of the petitioners, Lordship, and proposals afresh for seeking provincialization of the petitioners will be put up before the authority for necessary consideration, Lordship. Lordship, as per the compliance order, Lordship,
As per the
compliance order.
Compliance order that I have given that copy.
compliance.
Received it today, Lordship. Lordship, it says that arrear salaries to be paid to the petitioners by the school management
Managing
authority.
Not by the department of it.
Not by
That order, in fact, that order has been, addendum has been issued. And there is direction given to the SMDC lordships to release the arrear salary of the petitioner after receipt of the verification report from the inspector of schools.
The SMDC of Paschim Census shall be there to release the arrear salary of the petition after receipt of.
That is given to each SMDC lordship.
Lordship, if arrear salary is given, Lordship, which it means that the person will be terminated, Lordship. In the order, Lordship, it has nowhere indicated that the petitioner should be terminated, Lordship. If a person is working in the whose services are taken by a venture school, Lordship, if he is not provincialized, Lordship, does not indicate that he should be terminated, Lordship, from service. Because
If he is
once
not-
arrear salary is paid, Lordship, he or she will be terminated from service, Lordship. In the judgment of this honorable court, Lordship.
Yes, let us see what is to be done by the court. What is the direction passed?
Direction only to pass a speaking order after.
To pass a speaking order in respect, if the order provincial was issued on the basis of correct documents, where it is reflected that the subject concurrence was received after so in that event, the government takes a decision that provincial ought to be cancelled, then we have to put a problem. Cannot rely on clause 5 of the order to arrive that the order have been dealing. In the event of find that the now you see, whatever it is now at the end of the day, this has been done. Now this cannot be gone into in a contempt.
We have issued this.
But Lordship, with this, Lordship, I agree, it's a compliance order, Lordship, but not fully compliant, Lordship.
If they agree, they can challenge
Order,
this.
Lordship.
If there any grievance against this order, lordship, they can challenge it. After we have found that she was appointed, that concurrence was given after 1/1/26. So it is contravening of that rule, lordship.
So your compliance order was given after 1/1/2006.
Subject concurrence, Lordship.
Huh?
Yes, subject concurrence.
Subject concurrence, Lordship. I agree to it, Lordship.
Then?
But the Lordship, the second observation that the school management authorities will be paying the salaries, Lordship. And the school management authority will be directed to pay salaries, Lordship.
It is their responsibility, not the department is not responsible for that, lordship. We have already given the
Unless they are provincialized, then they have got no role to play.
But they're still working, Lordship, and their services are all.
The school management committee, they will pay if they are continuing.
They're still working.
Yes, that is what.
Still working, Lordship. It's nearly 3 years, Lordship.
In addendum, we have also given the direction to the SMDC, lordship. But so far, department is concerned.
But that portion has not been clarified by the court.
Yes.
But
Yes,
Lordship,
lordship. That is also there.
but that indication is given that that it's not termination order, Lordship. That they cannot be terminated, Lordship. That aspect needs to be.
No, but then you see, the provincialization is cancelled. That's all. They're not terminated from service. Provincialization.
Then they will still work, Lordship. If they are still working, their salaries need to be paid not by the department, not by the director, Lordship, but by the school authorities, Lordship.
School authority is not a party before the honorable court in this contempt, lordship. Only department is.
Because they were not a party in the writ petition, Lordship. So in the contempt, it is.
So that will arise to another set of lordship petition. So they'll have to come before the honorable court against the managing committee.
Mr. Gogoi, what do you say?
Well, probably the word area has been added. Because till that day, if they are working, it will of course be an area salary matter. Now, for the subsequent money, it will be current salary matter. That the authorities will decide.
SMDC will decide.
Probably for that reason, the director has passed the order stating that the area should be paid. Because till the decision is taken, my lord, already there are area dues.
Arrear used to be paid for SMDC, but with government money or what?
So from their own.
From their own.
From
Their own money. They
Because,
don't
my lord,
have-
Again,
but, my lord, that is the order of the honorable court, my lord, that only not provincialized, it will be the liability of that.
That specifically said in
That now the problem is in a contempt, we cannot go into
all the
the,
merits.
yes, we cannot go into, we cannot make observations also.
Yes, sir.
Lord.
We cannot pass directions. We cannot make
So,
observations
mandamus
also.
contempt.
Huh?
Mandamus also cannot be issued in
No,
contempt.
cannot.
Only-
That is the problem.
but that aspect will always remain grey.
So why not file a fresh writ?
Liberty may be
Their
granted.
liberty may be, their observation may be there in today's order.
Their salaries may be paid lordship till like.
That also cannot be given because they are not a party.
I cannot pass observations.
order.
No,
Yes.
that's the problem. You file a writ. How does it matter? This gives you a new cause of action.
Yes, yes, sir.
After the speaking order, new cause.
A new cause of action arises. And you'll have to show that this issue was not decided by the court earlier. This aspect of the matter.
Yes.
Was it decided this aspect of the matter earlier?
Lordship.
No.
Then. So how can I go into it in a contempt?
Lordship, but it won't be fully compliant lordship if it is close to the lordship. That aspect will always.
So far
remain.
department is concerned, we have nothing to do. We have already complied. It is the SMDC, they will subsequently they will have to pay. So we have already complied with the order.
You see, but for the period that they have worked, you'll have to pay.
No, madam, if they are not provincialized, so it will be upon the SMDC. only.
There is a specific direction in para
Direction of
15
the-
also, to the SMDC. Para 15 lordship, there is a specific
Lordship,
direction to
see
the
my lord,
Para?
last-
para 15 lordship, page 27.
The fifth line, my lord, of para 15, from the
Yeah.
bottom fifth line,
Yeah.
in the event.
In the event the department finds that their provincialization is in contravention with the provision of the act, then a school management authority will be directed to pay the salaries to the of the petitioners and proposal address for seeking provincialization of the petitioners will be put before the authority of the necessary for necessary consideration. The onus is on the SMDC law. And accordingly, in the addendum lawsuit, we have directed to the East SMDC lawsuit to release the arrear salary.
But they had been provincialized by the director. Maybe wrongly, but by the director.
Only wrong.
Only, my lord, they are qualified to be provincialized, but my lord, the procedure adopted was not proper, so.
With the concurrence that was received after 1
After to that 112,000. But anyway, this issue of them being provincialized has been wrongly made by you. Why shouldn't you pay?
But direction is not that the direction is to the SMDC lawsuit. It's a clear direction. Lawsuits. And the
Madam is very
has to notify.
difficult.
They have to-
Because it's quite clear here that in the event the department finds that the provincialization order is in contravention with the provisions of the act, then the school management authority will be directed to pay. In this contempt, it will be difficult to
But
decide.
the last line is very clear. It says that and proposals expressed for seeking provincialization of the petitioner.
No, you see,
Thereby that matter, they cannot be discontinued, matter.
but then this directed to pay the salaries, does it mean for the service rendered also? Cannot be. For the service rendered, maybe for the future, not for the service rendered.
That a school management authority, they will decide about it.
On the, you see, on the principle of quantum merit, you have availed the service of them.
Yes.
You have made the wrong provincialization order without, paying, while being negligent, because you did not take into account the issue of whether the subject concurrence had been given prior to or after 2006. That was your mistake, not their mistake. Your mistake. Now, why should you pay for the period at least for which they have worked?
As a provincialized service.
Ah.
Yeah, of course.
Because
For that, they have to go for modification of this particular paragraph clause. Otherwise, it will be difficult. They have to do a review.
Either review, I think review will have to be
Review will have
paid.
to. Review will have to.
Because I cannot go against this order, no?
Yes, sir. Review file for modify para 15.
Because you see, you can always say that it was due to the fault of the director
Yes, sir.
that you were provincialized.
And
Now
continue-
suddenly I am without pay. How can it
Continue for long.
And you see, till the day you are found, till the decision of the director, everything was okay. You were a provincialized employee. It's only from the day that they found that you were not a provincialized thing that the effect has started with regard to who should pay the amount. I think you have to find a review.
Yes.
Difficult for me, madam. I cannot. Because you tell me how am I going to overcome this?
Yes, sir.
Lordship, maybe please not to close this contempt, Lordship. I'll file review, which liberty may be given to file them.
We have already complied, Lordship. Contempt may be-
Order has been, huh?
But that aspect will always remain Lordship vacant.
But after review, if anything modified, they cannot come into this contempt case, Lordship. They have to file a separate, that will be modified order. Will be new order.
You see, you're only asking for a review, but then also whether review will lie. That is, you see, because it's not an error apparent on the face of the record.
Yes.
It's a direction.
No.
Okay, it's not an error apparent.
On one point it can be done because my lord, the fact remains that my lord, honorable court has categorically held that if at all, if there is any contravention, then their proposal will have to be submitted again. So
And
till that point
another
of
thing, it has not clarified as to whether the payment of salary has to be done subsequent to the finding that the provincialization order was wrong, or whether it will also cover period prior to the finding. So that way you can ask for a clarification and say that that finding made by the director will only come into force with respect to the service subsequent to your provincialization order being cancelled or withdrawn, not the period prior to, because you have worked as a provincialized employee due to the fault of the director, of the government, of the department. So that way, I don't think.
That will have to be paid by the department.
Yes.
Yes.
I think you can do that, or maybe file a. But it will have to be a review. I think.
Which part it will have to be?
They'll have to file a review.
I thought fresh writ, but I think review. Because this closure of the contempt that does not change anything.
Anything, yes.
Does not change anything. I think that's the only way out. So you can say that this is ambiguous. This portion of the order being ambiguous, they have interpreted it this way, which cannot be. It should be interpreted to the effect that the period prior to the finding of your order being incorrect, it should be paid by borne by the state. After the withdrawal of the provincialization, that may be borne by the school, but
SMPC.
prior to that, since I was a provincialized employee, on the basis of a decision taken by them, why should I suffer for that?
Yes, yes.
Why should I be penalized?
The petitioners were not party to the decision, so it is
Yeah,
entirely.
correct.
up to the-
No, that way, you cannot. Then if that doesn't work, go to appeal.
Lordship has given the ground up for that.
I'm just thinking because, yes, because
Otherwise, may not be-
they're not, what about the pay? They're not going to get any pay. But I don't think this court can do it, not in a contempt.
In the contempt, yes.
Because everything is quite clear here. And this clarification will have to be made by the court who made it. Because their interpretation, you can say their interpretation is wrong. The intention of the court was this. If he says no, then my lord, please clarify. Okay. Unfortunately, can't be helped sometimes.
Yes.
Okay, right. I heard Miss R. Barwa, learned counsel for the petitioners. Also heard Mr. SMTGC, learned counsel for the respondent number 1, 2 and 3,
Yes.
and Mr. B going for respondent number 4. The contempt petitions have been filed on the ground that paragraph 15 of the judgment and order dated 8/2/24 passed in a batch of writ petitions, that is WPC 7317/2022. It's and others has not been complied with. Para 15 of the judgment and order dated so states as follows, page 27. Next para. Mr. SMT Chisti has submitted orders dated
Six, 3/2025. In a issued by the secretary. And thereafter lawsuit. Director, that will be 27/3/2025 by the director.
issued order dated, has submitted order dated. No, has submitted the following orders. Number 1, you're right. Number 1, order dated 6/3/2025 issued by the Secretary to the Government of Assam, Department of School Education. Number 2, you're right. Order dated 27/3/2025 issued by the Director of Secondary Education. Then number 3, you're right. Addendum dated 4/4/2025 issued by the Director of Secondary Education. Next. The order dated 6/3/2025 issued by the Secretary to the Government of Assam, Department of Education, Department of School Education. Is to the effect that the subject concurrence for the subject being taught by the petitioner was issued after 1/1/2006, which was not in compliance with the provisions of the Assam Educational Provincialization of Services Act, 2017, as amended in 2018, and hence provincialization of the service of the petitioner should be cancelled. Next para. Let the orders dated the 27/3/2025 issued by the Director of Secondary Education, Assam, is to the effect that the provincialization orders of the petitioners were revoked as the subject concurrence for the subjects being taught by the petitioner had been received only after 1/1/2006. Correct?
Yes.
The order further stated that the petitioners, inverted commas, shall no longer be entitled to the benefits, privileges and conditions associated with provincialization. So stop, inverted commas. So you see, it says shall no longer. Shall no longer means from the date, from the 27/3. Doesn't talk about prior to. Okay. So stop. Next, the addendum dated 4/4/2025 issued by the Director Secondary Education, Assam, is to the effect that the School Management Development Committee of the schools in which the petitioners are teaching shall be directed to release the arrears salary of the petitioners, after receipt of the verification report from the inspector of schools with regard to the service rendered by the petitioner in the respective school. I think review not necessary.
But very specifically in the last line, it has stated that it will be.
Para 15, that particular line has to be reviewed, Lordship. The direction to the SMDC. As per that order, only SMDC will have to pay.
Direction is specific.
No, where?
Para 15, Lord.
Yes.
Which one we can do? In the event of the department finds that provincialization.
Anyway, we'll close this anyway. You decide whether you want to go.
Yes.
Because that order, not the addendum, prior to the addendum, that order says no longer. When you say no longer, it means from that date only. But they have made the addendum. That is a good ground for going anyway. Full stop. Next. On a reading of the order, on a reading of the orders, on a reading of the orders and addendums mentioned above, it is quite clear. Now, it is the view of this court that the judgment and order dated so has been complied with. Full stop. However, there is some ambiguity in the order dated 27/3/2025 and the addendum dated 13/10/2020, no, 4/4/2025, issued by the Director of Secondary Education, Assam, which is to the effect that no, in as much as the order dated 27/3/2025 states that the petitioner shall no longer be entitled to the benefits, privileges and conditions associated with provincialization. This appears to show that the benefits, privileges and conditions associated with provincialization would not be available to the petitioner from 27/3/2025 and not from a date prior to 27/3/2020. That's all. The contempt petitions are accordingly closed. Then this one, what will I do? I have to mark, no? I'll just say, just say the order dated, order dated 6/3/2025 is made a part of the record and marked as annexure X.
For each case, there is
I know, while the order dated 27/3/2025 is marked as annexure Y. The addendum dated 4/4/2025 is made a part of the record and marked as annexure Z. So I'll sign each, you just write. Okay.
The same order in each.
That's all. Finish.
Will
One.
be a common order for the.
Common order. Common order. Common order is easy. Just say, Mr. B. Gogoi appears for his point number 4. In that, they don't mention
Item 37.
and don't mention it. Common order doesn't matter. How does it matter? How does it matter? Just say appears in all the contempt petitions except for item contempt petition 30/30. Just say contempt case number C 24/25 and 29 of 25. That's all. 52, what is 52? Come, Miss Kemprai. That is why we are going to dispose of this matter. No one appears for the petition on call, while Miss S. Kemprai appears for the
Number 3, 4 and 5.
3, 4 and 5. Yes. This court, while no, full stop. It is also noticed that the petitioner has not been present on the last two court dates also. The Lavazima court proceedings dated 2/5/2023 shows that the petitioner had been again directed to take fresh steps for service of notice upon the respondents number 25, 26, 44, and 45 by a registered post with AD, as well as by usual process. The same not being done, the Lavazima, the same was not the same. The fact that the same was not done is recorded in the subsequent order dated 28/6/2024. And 13/8/2024. Better. You said 28/6/2024, comma 13/8/2024. 2/9/2024. 3/9/2024 and 3/4/2025. Further, the Lavazima court proceedings show that the petitioners had not been represented before the Lavazima court on the dates mentioned above. On considering the above, it appears that the petitioners are not interested in pursuing the matter. The writ petition is accordingly dismissed for non-prosecution.
Pending item 5.
No one appears for the petition on call. Mr. P.K. Bora appears for the elementary education permit. In the interest of justice, list the matter after a month.